Yes.
Maybe pardon to mention one WPC error for recovery of the minor daughter of the.
Yeah.
My lord, fresh admission matter, double P serial, my lord.
Yeah.
14 years. My lord.
Yes, you form two. এটা কোন অবিয়া কোন মেনশন করছে এটা বেল ম্যাটারটা সিঙ্গেল বেঞ্চ ম্যাটার
My lord.
It's a single bench matter. You do not know that
Yes,
now it's said.
my lord, actually there is an
Yes. No. All that. Item 28 after.
item 28.
Come to page 31. Miller.
My lordship. Page 31 na FR man.
Yes.
Mu bulu nahak sonso
Is
man.
PW? Informant is PW?
Four man.
Okay.
Brother of the deceased man.
Read it.
ଏହି କି ଯେ ଆଜି ତା 21/1/2006 ଶନିବାର ରାତିରେ ଆମ ବାରିପଟେ ଭିଡିଓ ଲାଗିଥିଲା। ମୁଁ ସେଠି ଭିଡିଓ ଦେଖୁଥିଲି। ରାତି ପ୍ରାୟ 12ଟା ବେଳେ ମତେ ଆମ ସାହି ପିଲାମାନେ ଖବର ଦେଲେ ମୋ ଭାଇ ବାବୁଲା ନାହାକକୁ ଘରେ କିଏ ଭୁସି ଦେଇ ପଳେଇ ଗଲାଣି।
Babula Naik is the deceased.
ଡିସିସ୍ ମାନେ ମୁଁ ଆମକୁ ଘରକୁ ଆସି ମୋ ଭାଇ ବାବୁଲା ଦାଣ୍ଡ ଘର ଏରୁଣ୍ଡି ପାଖରେ ପେଟକୁ ଭୁଷା ହୋଇ ରକ୍ତ ବାନ୍ତି କରି ପଡିଥିବା ଦେଖିଲି। ସେ କଥାବାର୍ତ୍ତା କରି ପାରୁନଥିଲେ। ମୋ ଭାଉଜ ବିଶୁକୁ ପଚାରିବାରୁ ସେ କହିଲେ ଯେ ମୋ ଭାଉଜ
PW6. ବିଷ୍ଣୁ ହେଲା PW6.
ତାଙ୍କ ଛୋଟ ପୁଅ ଦୀପକ ସହ ଦାଣ୍ଡ କବାଟ ବନ୍ଦ କରି ଶୋଇଥିଲେ। ରାତ୍ର ପ୍ରାୟ 12ଟା ବେଳେ ଭାଇ ବାବୁଲା ଭାଉଜକୁ ଉଠାଇ କହିଲା ତାକୁ କିଏ ଭୁସି ଦେଇ ଦାଣ୍ଡ ବାଟେ ପଳେଇ ଗଲା। ମୋ ବାପା ଭିଣେଇ ଗୋବିନ୍ଦ ମହାକ ଓ ଅନ୍ୟମାନେ ମିଶି ମୋ ଭାଇ ବାବୁଲାକୁ ବାଲିପଦର ସରକାରୀ ହସ୍ପିଟାଲରୁ ଆଣିଲେ। ଡାକ୍ତର ବାବୁ ମୋ ଭାଇକୁ ଦେଖି ଗଲେଣି ବୋଲି କହିଲେ। ଶୁଣିଲା ମୋ ଭାଇ ନରେନ୍ଦ୍ରକୁ ଗ୍ରାମର ଚାପ ଦାସର ଝିଅ ବିଷ୍ଣୁ ଦାସ ଆଜକୁ 7 ବର୍ଷ ତଳେ ବିବାହ କରିଥିଲା ଓ ତାର ଗୋଟିଏ ପୁଅ ଓ ଗୋଟିଏ ଝିଅ ଅଛନ୍ତି। ଚାପ ଦାସ ତାର ସ୍ତ୍ରୀ ମାୟା ଦାସ ସହ ଗଣ୍ଡଳ
Chapadas is the appellant.
appellant my lord. Yes. This is son-in-law of the appellant my lord.
Right. Yes.
ମାରପିଟ କରିବାରୁ ଆଜକୁ ମାସେ ହେବ ମାୟା ଦାସ ଆସି ମୋ ଭାଇ ପାଖରେ ରହୁଥିଲେ। ଏହି ବିଷୟରେ ଚାପ ଦାସ ବାଲିପଦର ମୋ ଭାଇ ଘରକୁ ଆସି ମୋ ଭାଇ ସହ ଗଣ୍ଡଗୋଳ ମଧ୍ୟ କରିଥିଲା। ଏହି ବିଷୟକୁ କେନ୍ଦ୍ର କରି ଚାପ ଦାସ ଗତକାଲି ରାତିରେ ମୋ ଭାଉଜ ଓ ତାଙ୍କ ପୁଅ ଶୋଇଥିବା ଅବସ୍ଥାରେ ଘରେ ପଶି କୌଣସି ଧାରୁଆ ଛୁରୀରେ ମୋ ଭାଇକୁ ଭୁସି ମାରି ଦେଇଥିବା ପୁରା ସନ୍ଦେହ ହଉଛି। ପୂର୍ବରୁ ସଂଶୋଷ ଦେଖିତେ
just a minute. Maya Das is PW8.
8. And
That
PW
means
6.
she is the mother-in-law of the appellant.
Yes, ma'am. Wife of
Chapada.
wife of the accused, ma'am.
Heh,
Yes, ma'am. Wife of accused भी हो सकती
wife of the accused होची PW6, wife of the appellant.
deceased wife.
Deceased
ये
wife.
deceased wife.
This is the way Vishnu.
Vishnu, अच्छा हाँ.
हाँ, PW 6 में लगता है.
Okay. তাহলে মায়া দাস কি?
My that's wife of the
Chapoda.
accused.
ও চাপ্পো দাস, আচ্ছা আচ্ছা. তো
ये son-in-law को
আচ্ছা জাস্ট wife of appellant. ତାହେଲେ ମୋର ଭାଇ ନରେନ୍ଦ୍ରପୁର ଗ୍ରାମର ଚାପ୍ପୋ ଦାସର appellant ର ଝିଅ ବିଷ୍ଣୁକୁ ଆଜକୁ 7 ବର୍ଷ ତଳେ ବିବାହ କରିଥିଲା. ତାଙ୍କର ଗୋଟେ ପୁଅ ଝିଅ ଥିଲେ. ଚାପ୍ପୋ ଦାସର ସ୍ତ୍ରୀ ମାୟା ଦାସ. That means the appellant's wife. Okay. ସହ ଗଣ୍ଡଗୋଳ ମାରପିଟ ହେବାରୁ ଆଜକୁ ମାସେ ମାୟା ଦାସ ଆସି ମୋ ଭାଇ ପାଖରେ ରହୁଥିଲେ. ଏଇ ଲାଇନଟା କଣ ବୁଝି ହଉନି? ଚାପ ଦାସ ତାର ସ୍ତ୍ରୀ ମାୟା ଦାସ ସହ ଗଣ୍ଡଗୋଳ
ତାଙ୍କର ये wife ସହିତ ଗଣ୍ଡଗୋଳ କରୁନି ଜ୍ୱାଇଁ ଘରେ ଆସିଲା.
The appellant and the Pidul 6 my lord. Both husband and wife, there was a quarrel between the both of the husband and wife, my lord. To save the life of the appellant, Pidul 8 my lord, the deceased brought him to his house, my lord. There, my lord, the occurrence took place because why?
আচ্ছা চাপ দাস তার স্ত্রী ମାୟା ଦାସ ସହ ଗଣ୍ଡଗୋଳ ମାରପିଟ କରିବା ଆଜକୁ ମାସେ ହବ. ମାୟା ଦାସ ଆସି ମୋ ଭାଇ ପାଖରେ. And wife of the appellant was staying with
With
the deceased.
house of
Yes, yes. ତାଙ୍କ ଭିତରେ କୋରେଲ ହେଲା ବେଳକୁ ଇଏ ଯାଇକି ତାଙ୍କ ଘରେ ଥିଲେ.
Okay. So ଏଇ ଯୋଉ FIR ରୁ ଜଣା ପଡୁଛି ଯେ ଆଇ ୱିଟନେସ୍ କିଏ ଆଦେରେ?
ସେ they claim that PW 6 and 8 ମାନେ wife of the deceased ସେ ମାରିକି ଗଲା ବେଳକୁ ତାଙ୍କୁ ଦେଖିଛନ୍ତି ଆଉ PW 8
PW
ହଁ
no ଆଇ ୱିଟନେସ୍ କିଏ କୁହନ୍ତୁ ଆଗେ ତା ଏଭିଡେନ୍ସ କହିବୁ ଯିବା.
PW 6 I am placing ମାନେ
PW
page 58 ମାନେ I am placing. The informant Bulu Naik is the younger brother of my husband.
ଟିକେ ରୁହନ୍ତୁ. Informant Budu Naikala PW. The younger brother of my husband. Okay. Yes.
The informant Bulu Naik is the younger brother of my husband. Accused standing in the dock is my father. Deceased Bula Naik was my husband. Deceased Babula Naik as was my husband. I was given in marriage to the deceased Babula Naik 7 years before his death. 1 year and 8 months back, my husband.
ଟିକେ ରୁହନ୍ତୁ. ଇଏ ଶ୍ୱଶୁର ମର୍ଡର କରିଛି ଜ୍ୱାଇଁ. ତ ଇଏ ମାନେ ତାର ଝିଅ ଯିଏ ହଉଛି PW 6 ବିଷ୍ଣୁ ସିଏ ବାହା ହେଇଥିଲା 7 ବର୍ଷ ତଳେ appellant sorry
Deceased.
ବାହା ହେଇଥିଲା. ତାର ଗୋଟେ ପୁଅ ଗୋଟେ ଝିଅ ଅଛି. ତାପରେ ଏଇ ଯୋଉ କଳିଟା ହେଲା କାହା ଭିତରେ ହେଲା? ଚାପ ଦାସ ମାନେ ତ ହେଲା ମାନେ ହଁ ଏଇ ୱିଟନେସ୍ ର ବାପା. ଏ ୱିଟନେସ୍ ର ବାପା ଆଉ ମା ଭିତରେ କଳି ହେଲା. ମା ଆସି ରହିଲା କାହା ପାଖରେ ନା ଡିସିଜ୍ ପାଖରେ. ମାନେ ଓକେ ହଁ ତାମାନେ ମା ଝିଅ ଗୋଟେ ଜାଗାରେ ଜ୍ୱାଇଁ ଗୋଟେ ଜାଗାରେ. Okay.
16 days before the occurrence, as the accused subjected to my mother to torture and harassment, my husband brought my mother Maya to our house to save her from torture
Maya
and
Maya
harassment.
examine ଆପଣ ତରତର କାହିଁ ହଉଛନ୍ତି କୋଉଠି ଅନ୍ୟ କୋର୍ଟରେ ଯିବାକୁ ଅଛି
No,
କି?
no, madam.
You are arguing a criminal appeal.
No, madam. Sorry.
Maya is PW 8.
8.
Yes. Yes.
Not placing, madam. My husband brought my mother Maya to our house to save her for torture and harassment
For ଲେଖା ହେଇଛି
from torture. From
Yes.
torture and harassment.
ପ୍ରତ୍ୟେକ ସେଣ୍ଟେନ୍ସ ପରେ ଟିକେ ରହିବେ ପଜ ଦେବେ.
Yes.
Yes. There is a
har-
way to understand. এটা novel ନୁହେଁ ଆପଣ ପଢି ଦେଇ ଚାଲି ଯାଉଛନ୍ତି. You are
Sir.
placing evidence of a witness, and before whom you are placing, they are to understand it. They are to follow it so that they can appreciate it.
Yes, ma'am. Sorry.
ତରତର ହେଇ ପଡି ଯାଉଛନ୍ତି.
Sorry.
Yes.
Torture and harassment.
Yes.
Out of the accused in my parents' house, my mother who is my father who is the father is the accused in this case is in habit of taking liquor and subjecting my mother to torture and harassment under the influence of liquor. My mother being brought by my late husband to my father-in-law house stay with us in our house. For this reason, the accused bore a grudge on my mother.
କଣ କହୁଛନ୍ତି ବୋର ଆନ କୋଉଠି ଲେଖା ହେଇଛି?
For this reason,
ବୋର ପରେ ଆନ କୋଉଠି ଲେଖା ହେଇଛି? Yes.
for
Read
this
again
reason,
one second.
yes, ma'am. For this reason,
Huh?
the accused bore grudge on my mother and was in a mood to kill her by stabbing. On one Saturday in the month of Magha, in the relevant night, myself, my mother had slept in our room with my small kid, and my husband had slept in the middle room of our house with my 5 year daughter, Varsha, in the night.
Said night.
In the said night. At the relevant time, I heard the sound of opening door of my house. I thought that my husband or my brother-in-law, Devara, might have opened the door from which I did not wake up. At that time, I heard the halla of my husband such as a bopa ma husi dela. Hearing such,
Just stop there. At that time, I heard halla of my husband, such as
ये बोपा माँ
ए बोपा माँ भूसी दला, ए बोपा माँ भूसी दला, नॉट कहा ना से कौन, ए बोपा माँ भूसी दला. Yes.
स्टैप करछि से तो पट्टे करछि बापा जने
बापा माँ में जिन जो पड़ी गले माँ माँ सो तो से बापा माँ भूसी दला. Okay.
On hearing such cry, I rushed to the bedroom of my husband and found that my husband was having bleeding injury on his belly and accused were decamping from the spot holding a knife in his hand. Seeing this, I shouted.
Just take pause for a minute. Informant एक केस रला किए? Is the younger brother of my husband.
Younger of the deceased man.
Mr. Das, এই জিনিসটা যদি সে দেখিলা তাহলে ତାପରେ କହିଥିବ PW4 କୁ PW4 ଆସିକିନି FIR ଦେଇଥିବ.
PW4 ତା पर लाइन रे अछि PW4 आछि कि चेस करे चेष्टा कला appellant को ता पर लाइन.
Where is that in the FIR? FIR को ଆଉ ଥରେ ଆସନ୍ତୁ. ମୁଦାଲା ସେଠୁ ତାକୁ କେହି ଦେଖିଥିଲା ସ୍ପଟ ରୁ ଦୌଡ଼ିକିନି ପଳଉଥିଲା. It's a very vital circumstance. ଆପଣଙ୍କର ଇନିସିଆଲ ଷ୍ଟୋରି ସେଇଆ ନୁହେଁ. ଇନିସିଆଲ ଷ୍ଟୋରି ହଉଛି ଏଇ ଯୋଉ ଏତଲା ଦିଆଯାଇଛି ଏଟା ସନ୍ଦେହରେ ଦିଆଯାଇଛି. ଆଉ ଥରେ ଆସନ୍ତୁ ପେଜ 31 କୁ।
Yes, ma'am.
ରାତି ପ୍ରାୟ 12ଟା ବେଳେ ଭାଇ ବାବୁଲା ଭାଉଜକୁ ଉଠାଇ କହିଲା, ମାନେ ଭାଉଜ ମାନେ ଯୋଉ ଆମେ ଯାହାର
PW
ଏଭିଡେନ୍ସ
6
ବର୍ତ୍ତମାନ ପଢୁଛୁ
Yes,
ହେଲା
sir.
PW6
These two.
ହେଲା, ତାକୁ ଉଠାଇ କହିଲା ଯେ ତାକୁ କିଏ ଭୁସି ଦେଇ ଦାଣ୍ଡ ପଟେ କିଏ ଏଗେନ୍ that see that ତାକୁ କିଏ ଭୁସି ଦେଇ ଦାଣ୍ଡ ପଟେ ପଳାଇ ଗଲା। ମୁଁ ମୋର ବାପା ଭିଣୋଇ ଗୋବିନ୍ଦ ନାୟକ ଅନ୍ୟମାନେ ମିଶି ମୋର ଭାଇ ବାବୁଲାକୁ ବାରିପଦର ସରକାରୀ ହସ୍ପିଟାଲକୁ ଆଣିଲୁ। ଡାକ୍ତର ବାବୁ ମୋର ଭାଇକୁ ଦେଖି ସେ ମରିଗଲେଣି ବୋଲି କହିଲେ। Then he has stated what has happened previously ଏବଂ ଏ ବିଷୟରେ ଚାପ ଦାସ ବାଲିପଦର ମୋ ଭାଇ ଘରକୁ ଆସି ମୋ ଭାଇ ସହିତ ଗଣ୍ଡଗୋଳ କରିଥିଲା। ଏ ବିଷୟକୁ କେନ୍ଦ୍ର କରି ଚାପ ଦାସ ଗତକାଲି ରାତିରେ ମୋର ଭାଇ ଭାଉଜଙ୍କୁ ସୁଆଂଶ ମାରି ଦେଇଥିବା ପୁରା ସନ୍ଦେହ ହଉଛି। Again you see that
ଆଜ୍ଞା
ହେଲା,
ଆଜ୍ଞା।
it is correct that FIR is not an encyclopedia,
Yes, exactly.
but when some such type of material evidence which is a very clinching evidence that is not mentioned, it is relevant under section 11 of the
Understand,
Evidence Act.
Yes,
Okay,
my lord.
so এই ঘটনাটা যদি PW6 ଦେଖିଲା, FIR story ହଉଛି PW6 ଶୋଇଥିଲା, ତାକୁ ଆସିକିନି deceased rather ଜଣେଇଲା
Yeah.
ଯେ କିଏ ଗୋଟେ ମତେ ଭୁସି ଦେଇ ପଳେଇଲା। ତାମାନେ deceased ନିଜେ ବି ତାର knowledge ନାହିଁ କିଏ ତାକୁ ଭୁସିଛି ଅନ୍ଧାର ରାତିରେ ଆସିକି, right?
But this also in the, my lord, in the right point. I'll go to the second line, my lord.
ହଁ
PW
କୋଉଟାରେ?
ସେଇଥିରେ PW6 ରେ.
Okay, come.
Again, it will clear, my lord.
ହଁ,
My lord is on the right point, my lord.
yeah.
Pardon.
Please continue. Seeing this, I shouted, directing the younger brother of my husband to catch hold the accused as he stabbed my husband with a knife. The younger brother of my brother chased the accused to catch hold of him. I
This is not an FIR.
I catcher hold.
ना catch hold of him.
Catcher लिख दीजिए, catcher
Okay,
hold
one.
of my husband as he was sustaining pain due to bleeding injury on his belly. But the younger brother of my husband returned and could not catch hold of accused. Myself and the younger brother of my husband took my injured husband to Bali Padar Hospital in a trolley rickshaw for medical treatment. At the relevant time, a kerosene DB was burning in the occurrence room. Paratopia. After half to 1 hour of our arrival at the hospital, my husband was succumbed to his injury
My
during
husband succumbed to
succumbed to his injury during the treatment. In the relevant night, the younger brother of my husband was slept in the front room of our house. The younger brother of my husband, Bulu Naik, reported the matter at police station. Police came to our house during the investigation and seized the debris, bloodstain, earth, and other matter from the spot as per seizure list already marked Exhibit 3 by 2 in my signature. Cross examination. At the relevant time, my father-in-law, mother-in-law, my mother were staying in the occurrence house beside myself, my husband, the younger brother of my husband, and my children. The right side immediate neighboring house was vacant, but I cannot say the name of the left side immediate neighbor of my house. At the relevant time, we are residing in a core pakka house and not finished house, and the house was under construction, and there is a no door lock and latches or hooks on the door of her house. At the relevant time of occurrence, I cannot say the
Full stop टाକୁ ଆପଣ ଛାଡ଼ି ଦେଇକି
full
କୁଆଡ଼େ
stop.
ପଳେଇଗଲେ
Sorry.
କେମିତି ହବ? The entire meaning will be different.
Certainly. I
And
cannot
there
say.
was no door lock and latches or hooks on the doors of her house at the relevant time
Relevant
of the
time of
occurrence.
occurrence. Fulton.
I cannot say.
I cannot say the width
Width and
and
breadth
length of the
length.
occurrence room. Full stop. I cannot say total area of residence house by length and width where we were residing. The danda of our house could be visible from back to front. We are using bari room as our kitchen at the relevant time, and also using the bari room as my bedroom. My father-in-law and mother-in-law were slept in the danda veranda of our
କି
house.
ଲାଙ୍ଗୁଏଜ ସେ କଣ ଲେଖା ହେଇଛି ଭଗବାନ ଇଏ କିଏ ଇଏ?
Correction नहीं, କିଛି ନାହିଁ, correction ନାହିଁ, ଗୋଟେ correction।
ଠିକ ଅଛି।
Veranda relevant time. I cannot say the distance between the danda veranda and place where my husband had slept in the relevant night. The accused is a habituated drunkard, expecting the drink. He has no other bad habit. My mother had not lodged any report against the accused about the torture and harassment meted out to her by the accused. The accused asked my mother to not to leave the house with my husband for staying in our house. When my husband brought my mother to our house, I was examined by the police.
କଣ ମିଶେଇକି ପଢିଦେଲେ?
ସେ ଗୋଟେ sentence ଟାକୁ ପଢିବେ। The accused ରୁ house ପର୍ଯ୍ୟନ୍ତ ଗୋଟିଏ sentence।
Yes, ma'am. I was
ତାର
examined by
ମାନେ ଅଲଗା ହେଇଯାଉଛି।
sir,
I was examined by the police
by
ଗୋଟେ sentence in itself. Yes.
the police first came to my house in the very night of occurrence day. But after arrival of the police, we took my husband to Bali Padar hospital from our house. 10 number of police staff had came to our house and
କେମ୍ ଲେଖା ହେଇଛି? ହାର୍ଡ ପରେ କେମିତି କେମ୍ ହବ?
sorry. Come to our house and 4 to 5 police accompanied us.
କଣ?
Accompanied.
ସେଇଆ ଲେଖା ହେଇଛି?
To the 10 numbers of the police staff and had come to our house and 4 to 5 police accompanied us to the hospital.
ସେ ଯୋଉ ପିଲାବେଳେ ସେ ଯୋଉ ସ୍କୁଲରେ ପଢା ହୁଏ
and the rest police staff remained at the
ରିମାଇଣ୍ଡ ଲେଖା ହେଇଛି?
remained sir.
You test your eyesight. I am sincerely advising you.
Yes, sir.
Either there is some problem with your eyesight, or in spite of our repeated hints that go slowly, you should read this brief time and again. Every
Police remained at the spot in the said night. I remained in the hospital about 3 hours in the night. By the time of my arrival at my house on my return from the hospital, police staff had already left my house for 5 minutes. It is not a fact that I had not stated to the police that while I was sleeping with my small kid and my husband was sleeping with my 5-year-old daughter, I heard the knocking sound of our door and that I thought that my husband or the younger brother of my husband might have opened the door or
Of our house.
our house, for which I did not wake up, and that at that at that time I heard halla of my husband stating Bopa Malo Bhusidala, and that hearing such a sound I rushed there and found the bleeding injury on the belly of my husband, and accused was decamping holding knife in his hand. It is not a fact that I had stated to the police that my husband told me that Vishnu, someone had stabbed on my belly and went away towards the danda of our house, and that one had covered his body with a gamucha at that time.
So this was the Mr. Das. This was the statement before the police. ଗୋଟେ ଲୋକ obviously ଯିଏ ଆସିଛି known person, he must have taken all steps to conceal the identity. ସେମିତି openly ଆସିକିନି ମାରିବ ମାନେ ଫଟକିନି ପଳେଇବ, ଏକେ ତ ଘୋଡେଇକିନି ଆସିବ। ତେଣୁ ଦେଖନ୍ତୁ ତା statement ପୂର୍ବରୁ କଣ ଥିଲା, ଯେ ଗୋଟେ ଲୋକ ନିଜକୁ କଭର କରି ଆସିକିନି ଗାମଛାରେ ଆସିକି ଇଏ କଲା, ସେଇଥିପାଇଁ ଇଏ ବି ଚିହ୍ନି ପାରନି ସେ। now he has stated that I have seen. Let us see his 161 statement, please. କାହାର ତା ନାଁଟା କଣ? ବିଷ୍ଣୁ ନାୟକର ବାହାର କଲେ ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ, ସେଇଟା ନୁହେଁ, ସେଇଟା ପେପର।
ଲଳିତା ନା
ଆରେ ବାବା ସେଇଟା ନୁହେଁ ସାର୍, ଏଇଟା ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡଟା ବାହାର କର, ଏଇଟା ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ। ଓକେ, ଲେଟ୍ ଅସ୍ ସି ବିଷ୍ଣୁ 60 କେତେ ନମ୍ବର ପେଜ? ତଳୁ ଖସିଲ 93 ମାରିଲ। ନା ନା ଏଗୁଡ଼ା ଏକ୍ଜିବିଟ୍ ଗୁଡ଼ା।
Okay, internal page of 15. Oh, 16, 17, 16, 15, 16.
ଏଇଟା କଣ ଲଳିତା ନାୟକ ବାହାରିଲାଣି?
हाँ ललिता है, नाम भी alias
अच्छा,
ललिता मैडम,
अच्छा,
विष्णु नायक alias ललिता।
So, Mr. Das, the statement goes like this. So and so, आज 7 ବର୍ଷ ତଳେ ମୋର ବାପା ଚାପଦାସ ମତେ ବାଲିପଦାରେ ବାଲିପଦରରେ ବନମାଳୀ ନାୟକଙ୍କ ପୁଅ ବାବୁଲା ନାୟକଙ୍କୁ ବାହା ଦେଇଥିଲେ। ବାବୁଲା ନାୟକ is the deceased, right? ମୋର ଗୋଟିଏ ପୁଅ ଗୋଟିଏ ଝିଅ ଅଛି। ଆଜି ରାତିରେ ଦାଣ୍ଡ ପଟ କବାଟ ବନ୍ଦ କରି ମୁଁ ମୋର ସ୍ୱାମୀ ପୁଅ ଦୀପକ ସହ ଘରେ ଶୋଇଥିଲି। ରାତି ପ୍ରାୟ 12ଟା ହେବ। ମୋର ସ୍ୱାମୀ ମତେ ଉଠାଇ କହିଲେ ଯେ ତାଙ୍କୁ କିଏ ଜଣେ ଲୋକ ଛୁରୀରେ ପେଟକୁ ଭୁସି ଦେଇ ଦାଣ୍ଡ ପଟ ଦେଇ ପଳାଇଗଲା। ଏହା ଶୁଣି ଉଠି ଦେଖିଲି ସ୍ୱାମୀ ଦାଣ୍ଡ ପଟକୁ ଯାଉଛନ୍ତି। ମୁଁ ପଛେ ପଛେ ଆସିଲି। ମୋ ସ୍ୱାମୀ ଘରର ଏରୁଣ୍ଡି ବନ୍ଧ ପାଖରେ ବାନ୍ତି କରି ପଡ଼ିଲେ। ପେଟରେ ଭୁସା ହୋଇ ଅନ୍ତ ବିଜୁଳି ବାହାରିଥିଲା। ସେ କଥାବାର୍ତ୍ତା କରିପାରିଲେ ନାହିଁ। ମୁଁ ପାଟି କରିବାରୁ ବହୁତ ଲୋକ ଜମା ହେଲେ। ମୁଁ ଶ୍ୱଶୁର ଦିଅର ମଧ୍ୟ ପହଞ୍ଚିଲେ। ମୁଁ ତାଙ୍କୁ ସବୁ କଥା କହିଲି। ଆମେ ସମସ୍ତେ ମିଶି ମୋର ସ୍ୱାମୀଙ୍କୁ ମେଡିକାଲ ନେଲୁ। ବାଲିପଦର ମେଡିକାଲ ପହଞ୍ଚିଲା ପରେ ଡାକ୍ତର ବାବୁ ମୋର ସ୍ୱାମୀଙ୍କୁ ଦେଖି କହିଲେ ସେ ମରି ଯାଇଛନ୍ତି। ମୋର ବାପା ମା ସହିତ ଗଣ୍ଡଗୋଳ କରିବାରୁ ମୋର ମା ମାୟା ଦାସ ମାସେ ହେଲା ଆମ ପାଖରେ ଅଛି। ତେଣୁ ବାପା ଆସି ଆମ ସହିତ ଗଣ୍ଡଗୋଳ କରିଥିଲେ। ମୋର ଜୀବନରେ ମାରିଦେବେ ବୋଲି ଧମକ ଦେଇଥିଲେ। ତେଣୁ ବାପା ମୋର ସ୍ୱାମୀଙ୍କୁ ସେଇ ରାଗରେ ମାରି ଦେଇଥିବେ ବୋଲି ସନ୍ଦେହ ହଉଛି। ଏହା ମୋର ଜମା ନୁହେଁ, କିଛି ନାହିଁ ଟୋଟାଲ। ଆଉ ଏଇ ଯୋଉ ଲାଇନଟା ପଚରା ହେଇଛି, ଇଟ ଇଜ it is not a fact that I had stated to the police. I would statement record that my husband told that Vishnu.
Just below it.
তার ইত্যাদি করে আচ্ছা ବିଷ୍ଣୁ ନାୟକ ଓକେ ଏଇଟା କେବେ ହେଲା ତାହେଲେ ପ୍ରଥମଟା ହେଲା 22/1/2006 ତଳଟା କେତେ ହେଇଛି
ସେଇ 22
ଓକେ
same.
ଆଚ୍ଛା ଏଇ ଆର ଗୋଟେ ଷ୍ଟେଟମେଣ୍ଟ ହେଲା ଶୁଣନ୍ତୁ ଆମେ ଏଇଆ ହଉଛି ବହୁତ ଥର ମଦ ପିଇ ମୋର ବୋଉ ମାୟାକୁ ମାଡ ମାରି ଗାଳି କରୁଥିଲେ ଏଣୁ ମୋର ବୋଉ 15-16 ଦିନ ହେଲା ମୋ ଶାଶୁ ଘରକୁ ଆସି ଏଠାରେ ଅଛି ଗତ ମକର ସଂକ୍ରାନ୍ତି ପୂର୍ବରୁ ମୋର ବାପା ବୋଉଙ୍କୁ ଖୋଜି ଏଠାକୁ ଆସିଲା ମୋର ବୋଉଙ୍କୁ ଛାଡି ଦେବାକୁ ମୋର ସ୍ୱାମୀ ଓ ଶାଶୁଙ୍କୁ ବାଧ୍ୟ କଲା ମୋର ସ୍ୱାମୀ ମୋର ବୋଉଙ୍କୁ ଯିବାକୁ ମନା କଲେ ଓ ମୋର ବଡ ଭାଇଙ୍କୁ ଆଣି ଆସିଲେ ବୋଉଙ୍କୁ ନେଇ ଯିବେ ବୋଲି କହିଲେ ମୋର ଆଚ୍ଛା ମୋ ବାପା ମୋ ବୋଉ ନାଁରେ ବୋଧେ କରନି ଗାଳି ମନ୍ଦ କଲାରୁ ମୋ ସ୍ୱାମୀ ଦିଅର ବୁଲୁ ମୋ ବାପାଙ୍କୁ 2 ଚାପଡ଼ା ଲେଖାଏଁ ମାରିଥିଲେ ସେତେବେଳେ ମୋର ବାପା ମୋର ପିଉସୀ ନାନୀ ନାୟକ ଗ୍ରାମ ଘରେ ଥିଲେ ସେତେବେଳେ ମୋର ବାପା ମୋର ସ୍ୱାମୀ ବୋଉଙ୍କୁ ପ୍ରାଣରେ ମାରିଦେବ ବୋଲି ଧମକ ଦେଇଥିଲା ଗତକାଲି ରାତିରେ ମୋର ସ୍ୱାମୀ ଘରକୁ ଫେରି ମୋର ସ୍ୱାମୀ ଆମ ଗାଁ ମିଲୁ କାମ ସରି ଆଚ୍ଛା ଘରକୁ ଫେରି ଖାଇଲେ ମୋର ବୋଉ ଝିଅ ଓ ଶାଶୁ ଘରେ ଖାଇ ତାଙ୍କର ନାତି ନୀର ଘରକୁ ଶୋଇବାକୁ ଗଲେ ଆଚ୍ଛା ମୋର ଶ୍ୱଶୁର ଖଳା ଜଗି ଗଲେ ଆଚ୍ଛା ଓ ଦିଅର ବୁଲୁ ଭିଡିଓ ଦେଖିବାକୁ ଗଲେ ମୁଁ ମୋର ସ୍ୱାମୀ ପୁଅ ଦୀପ ଖାଇସାରି ଆମ ମଝି ବଖରା ଘରେ ଦାଣ୍ଡ କବାଟ ବନ୍ଦ କରି କାଠ କଣ ଗୋଟେ ଲେଖା ହେଇଛି ଆଚ୍ଛା ଏଇ ଯୋଉ ଦିଆ ହେଇଥିବ କାଠ ଇଏ କରି ଶୋଇଲୁ ରାତି ପ୍ରାୟ 12ଟା ବେଳେ ମୋର ସ୍ୱାମୀ ମତେ ନିଦରୁ ଡାକି କହିଲେ ବିଷ୍ଣୁ ମତେ କିଏ ଭୁସି ଦେଲା ଦାଣ୍ଡ ପଟେ ଧାଇଁ ପଳାଉଛି ତୁ ଯାନା ମୁଁ ଦେଖିଲି ଜଣେ କିଏ ଆଚ୍ଛା ମୁଁ ଦେଖିଲି ଜଣେ କିଏ କଣ ଗାମୁଛା ଚଦର ଘୋଡି ହୋଇ ଦାଣ୍ଡ ପଟେ ଧାଇଁ ଗଲା ଦାଣ୍ଡ କବାଟ ଖୋଲା ଥିଲା ମୋ ସ୍ୱାମୀଙ୍କ ପେଟରେ ଭୁଷା ହୋଇଥିଲା ଇଲେକ୍ଟ୍ରିକ ବଲ୍ବ ଜଳୁ ନଥିଲା କଣ ଡିବି ଲାଗିଥିଲା ମୋ ସ୍ୱାମୀ ସେଠାରୁ ଦାଣ୍ଡକୁ ଆସିବା ବେଳେ ଦାଣ୍ଡ ବାଣ୍ଟୁଣିରେ ପଡିଗଲେ ମୁଁ ଧାଇଁ ଯାଇ ଡାକିବାରୁ ମୋର ସ୍ୱାଂଶ ମାନେ ଆସିଲେ ଲୋକମାନେ ମୋର ସ୍ୱାମୀକୁ ଗୋଟିଏ ଟ୍ରଲି ରିକ୍ସାରେ ବାଲିପଦର ସରକାରୀ ଡାକ୍ତରଖାନାକୁ ଚିକିତ୍ସା ପାଇଁ ନେଇଗଲେ ମୁଁ ଶୁଣିବାକୁ ପାଇଲି ଡାକ୍ତରଖାନାରେ ପହଞ୍ଚିବା ବେଳକୁ ମୋର ସ୍ୱାମୀ ମରିଯାଇଥିଲେ ଏଣୁ ମୋର ବାପା ସ୍ୱାଂଶ ମର୍ଡର କରିଛନ୍ତି ବୋଲି ମୋର ଦୃଢ ଧାରଣା କ୍ଲିୟର
As per the FIR corroborated one second.
ହଁ ଏଇ ଜିନିଷ FIR ରେ ମଧ୍ୟ ସେ ପାର୍ଟଟା ବି ନାହିଁ ଯେ ଦେଖିଲେ ବୋଲି କିଏ ଗୋଟେ ଯାଉଥିଲା much less to say about the accused ମାନେ ଟୋଟାଲି ସେ କେହି ଦୌଡ଼ିକିନି ଚାଲିଯିବା ମଧ୍ୟ ଘୋଡେଇ ହେଇକିନି ସେ ବିଷୟ ନାହିଁ ଏଇଟା ସେଇଦିନ ଦିଟା ଷ୍ଟେଟମେଣ୍ଟ ଯାହା ରାଇଟଲି ଇଟ୍ ହାଜ ବିନ୍ ପଏଣ୍ଟେଡ ଆଉଟ୍ ଦ୍ୟାଟ୍ 22 ତାରିଖରେ ଦିଟା ଷ୍ଟେଟମେଣ୍ଟ ହେଇଛି ହଁ ପ୍ରଥମ ଷ୍ଟେଟମେଣ୍ଟରେ ଆପଣ ଦେଖିବେ ସେଇ ଯୋଉ ବିଷୟ ଟୋଟାଲି ନାହିଁ ମାନେ ଦୌଡ଼ିଛି ଯେ ନାହିଁ ସେକେଣ୍ଡ ଷ୍ଟେଟମେଣ୍ଟରେ ଆସୁଛି ଘୋଡେଇ ହେଇକିନି ଦୌଡ଼ିଗଲା ଟ୍ରାଏଲ ଆସିଲା ଆକ୍ୟୁଜ କୁ ଦେଖିବେ so this is the difference between this now ଇଏ ଆଚ୍ଛା ଆଉ କଣ ଅଛି ସେଠି ପଢି ଦିଅନ୍ତୁ ଆପଣ କଣ୍ଟିନ୍ୟୁ କରନ୍ତୁ
page 60 matter last it is
we are
not
continuing from page number 60
matter last
okay. Last sentence
it is not a fact that I had not stated to the police that police visited the spot and seized debris blood stain earth and other articles from the spot under the seizure list
Yes, sir.
I do not find the seized article, particularly debris, in the court today, my lord. The 61, paragraph 5. Police collected the blood-stained earth from the occurrence room, but I cannot say the exact place of the room from where the police seized blood-stained earth. It is not a fact that I had not stated to the police that I asked the younger brother of my husband to catch hold of the accused, and he gave a chase to the accused to catch hold of him. Paragraph 6. I, I am a daily laborer, and I used to go to paddy land to be engaged by agriculture laborer during the harvesting season and cultivation season. My husband was working as a halia in our village. But, we used to cut paddy crops with a sickle, and sickles are available in our house. It is not a fact that my father, who is the accused, had not
Stabbed my husband with the knife.
stabbed my husband with knife. Uh, that my husband had a sustained injury on his belly due to fell on a sickle kept in our house while going to for urination from his bed in the darkness of relevant night, and due to previous growth, I am implementing the accused as the author of the injury of my husband
ଆଚ୍ଛା,
at
ଏଇ
the
ଯୋଉଟା
instance of
ପଚାରିଲେ ଯୋଉ କଣ୍ଟ୍ରାଡିକ୍ସନ ଆଇଲେ ସେ ତ ନଟ୍ ଏ ଫ୍ୟାକ୍ଟ କହିଲା ଆଇଓଟୁ ଏଇଟା ପ୍ରମାଣ କରିଛନ୍ତି with the investigating officer.
My lord.
Page number କେତେ
Page,
କହିଲେ?
my lord, frankly, my lord, 70.
With the IO.
11.
11, my lord.
11.
Just
Page
a minute.
74. para seven.
Just a minute.
କୁହନ୍ତୁ କିଛି time.
74. हाँ କୋଉ
Para 7.
ପାରା 7 ହଁ ଏଇଟା ହଉଛି PW6 ପଢିଲେ ସେଟା
Para 7. PW6 has not stated before me that he heard the knocking sound of her door and her door
ସାଉଣ୍ଡ କୁ ସାଉଣ୍ଡ କଣ ଲେଖିଛନ୍ତି ମାନେ ଡିକ୍ଟେସନ okay continue
and the husband and her husband, younger brother of her husband, or her husband might have knocked the door for which she wake up, but she had stated before me that her husband told that time the Vishnu
ମୋତେ କିଏ
Motikia
ଭୁଷିଦେଲା ବିଷ୍ଣୁ ମାନେ
Bhusidala,
ତାର ସ୍ତ୍ରୀ
Motikia
ନା ହଉଛି
Bhusidala,
ବିଷ୍ଣୁ ହଁ
but not stated before me that her husband told Bapa Ma Bhusidala. It is not a fact that all the exhibit and documents are created by me for the purpose of this case and to harass the accused, and that the accused is no way connected with the seed emoji. First of all, the accused had no earlier criminal
ଆଉ
antecedent.
କିଛି ପଚାରନାହାନ୍ତି ସେତିକି ସାରିଛନ୍ତି.
ଆଶ୍ଚର୍ଯ୍ୟ ମାନେ ଆରେ ସେଇଟା ଇନଫ୍ୟାକ୍ଟ ସେ କହିନି ମାନେ ଏଇ ଯୋଉ ଜିନିଷ
ହଁ ସେ
କହିଲା
particular portion ଟାକୁ ଆଣିନାହାନ୍ତି.
ହଁ ତ ପଚାରିଲି ଏଇଟା ଠିକ ରହିଲା
ଆଜ୍ଞା.
ମାନେ ଚିଫ ରେ ଏଇ ଯୋଉ ତାର ଇଏରେ ଠିକ ରହିଲା
ଯୋଉ part ଟାକୁ ଆମେ କହୁଛେ
Suggestion ଠିକ ଅଛି suggestion
ହଁ
ଏଠି ନାହିଁ.
ଇନଫ୍ୟାକ୍ଟ ନାହିଁ
ଆଜ୍ଞା.
ହଁ ପଚାରିଛନ୍ତି ମଧ୍ୟ ଆଇଓକୁ ବଟ୍ ସେଇ ଜିନିଷଟା ପଚାରିନାହାନ୍ତି
particular ଇଏଟାକୁ ଆଣିନାହାନ୍ତି.
ପର୍ଟିକୁଲାର ଏଇଟା ଆଣିନାହାନ୍ତି କଣ ସେ ଯୋଉ ଲେଖିନଥିବ ଏଇ ଟାଇପର ଇଏ ରେକର୍ଡିଂ ଏଭିଡେନ୍ସ But Mr. Das, there are one or two decisions that if the attention has been drawn and it has also been put to the IO proved, but inadvertently that word has been
Not
ଗୋଟେ inadvertently जोटा confront ହେଇଛି inadvertently ଯଦି ଇଏ କରାହେଇଛି the court in the interest of justice can see whether that
Exactly,
is there
that
or
is-
not that ଆମେ ପୁରା एकदम
Well,
total ଇଏ କରିପାରିବୁନି ସେଥିପାଇଁ ସେ ଯୋଉ ମାର୍କ ପୋର୍ସନ ଟା ହେଇଗଲେ ମାନେ that is the advantage of ତେଣୁ ଇନଫ୍ୟାକ୍ଟ ଆମେ ଭେରିଫାଇ କରିସାରିଲୁଣି ଏଇ ଯୋଉ ଲାଇନ ଟା
that is not there.
ହଁ ଦୌଡ଼ିକିନି ପଳଉଥିଲା ଆକ୍ୟୁଜ ଯୋଉଟା କି ଭେରି ମ୍ୟାଟେରିଆଲ
ତାକୁ ଧରିବାକୁ ଚେଷ୍ଟା କଲେ ସେ ଖସିଗଲା।
and suppose ବର୍ତ୍ତମାନକୁ ମଧ୍ୟ ଯଦି let us say he will file an application under 391 CR ହଁ to just for limited purpose এটা omit ହେଇଯାଇଛି ସେ ଆସନ୍ତୁ ସେ ଆସିଲେ ଏଇ କଥା କହିବ ନା ଇନଫ୍ୟାକ୍ଟ ସାର୍ ମତେ ମୋ ପାଖରେ ଏଇ କହିନଥିଲା ସୋ ଏଇ ଜିନିଷକୁ ଆନାଲାଇଜ କରିକିନି ମାନେ କହିଛନ୍ତି attention must be drawn of the concerned witness previous statement because that is the language of ଇଏ ଆଉ ଯୋଉ ସମୟରେ ଇଏ ଆସିବ ତାକୁ ମଧ୍ୟ ପଚାରିବାର ଦରକାର କିନ୍ତୁ ଏଇ ପଚାରିବା ଭିତରେ ଯଦି ଗୋଟେ ମ୍ୟାଟେରିଆଲ ଇଏଟା ଓମିଟ ହେଇଛି ମେ ବି inadvertently ହଁ so court in the interest of justice can
also-
see that 161 statement ସେଟା ହଉଛି ସେ ଇଏଟା ଆଣିଲେ କି ଦେଖିଲେ just ଗୋଟେ ଦେଖି ପ୍ରତ୍ୟେକ ଇଏର ଦିଟା ଲେଖା ପଡିଲା 75 76
But it is also to be seen if in the totality of the evidence, the portion of the confrontation which has been left out will completely jeopardize the whole evidence.
And
That
and
is-
if again will
if other evidence is there and that is
But,
only
but again, when we'll go to the evidence of the Schedule 4, again that contradiction will start again. Same FR and his statement regarding the contradiction of the IO, not mean.
ଇନିସିଆଲ ଷ୍ଟୋରି ହିଁ ନାହିଁ
ଆଜ୍ଞା
ଯେ କେହି ବି ଦେଖିଛନ୍ତି
ଆଜ୍ଞା that is not
ଆପଣଙ୍କର
there.
ହଁ
yes, it is a
A new story came out at the time of the evidence, recording of evidence.
ଏଇଟା ଦେଖନ୍ତୁ this is a case of the Honorable Supreme Court. This is AIR 1975 Supreme Court 1026 and party नाम ହେଲା Ram Kumar Pandey versus State of Madhya Pradesh. Paragraph number 9 is important. है ना? What their lordships have stated that no doubt an FIR is a previous statement which can, strictly speaking, be only used to corroborate or contradict the maker of it. But in this case, it had been made by the father of the murdered boy to whom all the important facts of the occurrence, so far as they were known up to 9:15 p.m. on 23/11/1970, were bound to have been communicated. If his daughters had seen the appellant inflicting a blow on Harvinder Singh, the father would have certainly mentioned it in the FIR. We think that omissions of such important fact affecting the probabilities of the case are relevant under Section 11 of the Evidence Act in judging the veracity of the prosecution witnesses. এই ଯୋଉ ସେଇ
ପାର୍ଟଟା ଯଦି
FIR ସବୁ ଜିନିଷ କହୁଛି ସେଇ ପାର୍ଟଟା ସେଇ କଣ୍ଟେକ୍ସଟରେ କହିଲେ ଯେ fact otherwise not relevant becomes relevant is So एठी आपणकर स्टार विटनेस होउची दी जण जाण गोटे होउची PW6 टा जहार एविडेंस टा से प्लेस कले आ गोटे होउची PW
8 and infant P 4.
अच्छा ओके 8 को जीवा तापरे आसो
8 को जागा 4 को
4 को जीवा ऑलराइट ठीक है
पेज 64 मिला page 64. Deceased Babula Naik being the husband of my
कोटा पड़ुची
PW 8.
No.
Sorry,
Schedule 4, Schedule 9. 52.
52 mile. I had orally reported the, I had orally reported about the occurrence before the police at Buguda PS. The accused is the father-in-law of my deceased brother Babula Naik. The brother, my brother Babula meet his death 1 year and 8 months back. In the relevant night, I was sleeping in the front room of our house. My deceased brother had slept in the middle room, and my wife, the wife of accused, namely Maya Das, was sleeping in the last room with the wife of my deceased brother. In that night,
Mayadas is PW8 na
yes, my PW, my last. In that night, at about 12:10 a.m., occurrence took place. While I was asleep, I woke up hearing hue and cry of my bhauja, wife of the deceased Babla, and found the accused running away towards Chak from our house. At that time, my brother was leaning to the wall with profuse bleeding on his belly due to stab injury. My bhauja told me that her father stabbed deceased Babula with a knife, causing profuse bleeding injury. Myself, my father, mother, bhauja, Maya Das carried the deceased to Bali Padar Hospital in a trolley. But the doctor declared my brother to be dead. As the wife of accused came away to reside with her daughter and deceased Babula to avoid physical assault and torture, subjected to her by the accused under influence of liquor. The accused bore a grudge and stabbed my brother as to why he allowed his wife to reside with us. The police reduced in my oral report report to writing, and I put my LTA on that report prepared by the police. I collapsed when the doctor declared my daughter to be dead in the hospital. I took siege, DB, silver Bengal, silver locket of my deceased in Jima, given by police. Cross examination method. Apparatus. I had slept in the Danda room of my house. Accused was running towards Danda from my house, and at that time I was sleeping in the Danda room. First off, hearing the sound, I went towards the Bari room. First of all, I have seen the accused running towards Danda from my house. First off, when my house cried, I came to know that the accused stabbed my brother by means of knife. But I have not chased the accused to capture him, but the other person tried to catch him but could not catch hold of him at the relevant time. It is not a fact that I do not have any knowledge regarding the occurrence, and being the brother of deceased, I am deposing falsehood against the father of my bhauja due to previous ill feeling. Hold up. The affair was scribed by police. The contents of the affair had not been read over and explained to me by the police. Only on being directed by police, I put my LTA below the report. That is the.
तो मिस्टर दास एगुड़ाक ये हूँ निजे इनफॉर्मेंट तो इतने जिनस सी जानी किसी टोटल नहीं जे निजे देखिला accused को दौड़ी की पड़े जाउथला तापरे ता भाउजो आसिला भाउजो तो निजे जानिनी कि भाउजो आपका आसी पड़े कहिला जे तार बापा ताकू स्टैबिंग कला बेले
Again, if we'll come to the my lord spot map, my lord. There, the first room, the brother, people 4 are sleeping, my lord, and the second room, the deceased are sleeping. The next room, the others are sleeping, my lord.
No,
Someone will enter to the room.
ना ये जो स्पॉट हाउस रे
आगे
आपण से स्पॉट हाउस टाକୁ देखैछि एस बेली
yes ma'am मजिटा D1 जो लिखा था मजिटा D1 टा फर्स्ट डोर टा जोड़ा दांडो डोर टा वुडन डोर टा
अच्छा एस टा होछि स्पॉट रूम माने
एस टा मजिटा
माने D2 टा जोटा
D2
राइट एस 1 टा देखुछि ओटा काउ सेड छै छाड़ हां सो आगे तांको घर को पसिया को हेले
D1 देख पसिले
ना स्पॉट ठीक है वेट वेट पेपर बुक का बाहर पेपर बुक रो एटा 81 पेज रे पेज नंबर अरे 81 पण
पेज 81
81
82 मिसी गछ
81.
ठीक है
85
अच्छा 85 81 लिखा है
81
82.
81 हां ये चाहूं ये पढ़ दे चाहूं ठीक है इस वन का हो इस वन का चलो कौन
काउ सेड ओटा पछडा बैक साइड ओदी
पछे तो ये रास्ता रू प्रथमे आसीले आगे D1 दे पास एमती हां ठीक D1 रे सोइतला कि PW से घर क्रॉस करले जाई कि डिसीज रूम को पछे अच्छा बाकी जो अन्य माने सोइतले जो D3 जो लिखा छै से रूम ता परटा लास्ट राइट सो हां सेटा में डोर टा देखौछि से रूम हां माने ए इनफॉर्मेंट
ये बाहरिबो इरा
हां गोटी तो
गुसई पटे ही बाहरियो न पछोटे बाहरियो
पछपटे बाहरियो जीव से जो
सेट पड़ते की जीव
there is no other way out तेणु on that day जदी भी जो accused आसीथिबो सेई पटे से घर क्रॉस करि से पटे पछियो अपन से पटे बाहर सेई पटे बाहरी कारण अन्य रूम जदी बंद थिबो तेणु माने जो सोई थिला ये सिगर गोटे साइड रे पैडी बैग्स गुडा को रही हां था कमर राइट
D2 टा होछि टाटी डोर
हां
जस्ट टू हां हाउ जाय लास्ट
एटा इंटरनल रोड टा हां किंतु मेन रोड टा होछि D1 टा होछि वुडन डोर माने मेन डोर टा घर
एमाने जो सोइथिले एठी
हां से
कबाट कम करे सोइथिले बोली को
हां ମାନେ
ସେପଟ ରୁମ ରେ ପଶିବାକୁ ନାହିଁ, ବାହାରିବାକୁ ବାଟ ନାହିଁ।
ସେପଟେ ନାହିଁ, ସେଇ ତ
ସେଇପଟେ ଯିବାକୁ
ପଛପଟେ ସେ ପଶିନି, ମାନେ ତାଙ୍କର ଯଦି ବି ପଶିଥିବ ସେ ସେଇ ଫ୍ରଣ୍ଟ ଦେଇକିନି ରାସ୍ତା ପଟୁ ପଶିଥିବ, ତାହେଲେ ପ୍ରଥମେ ଆଗେ କ୍ରସ୍ କରିଥିବ ସେ ଯୋଉ ରୁମ ଟାରେ ଇନଫରମାଣ୍ଟ ଶୋଇଛି, ଏବଂ ତାପରେ ଦେନ୍ ଆସିକିନି ଷ୍ଟାବିଂ କରିଥିବ ଯଦି ଏଇ ଯୋଉ ଆକୁ ଡିସିଜ୍ଡ କୁ, ଏବଂ ବାହାରିକିନି ସେଇପଟେ ଯାଇଥିବ।
It also appears from the statement that somebody he must have knocked and then opened. କଥା ଜଣାକୁ ସେମାନେ ବିଷ୍ଣୁ କହୁଛି ଆମେ ବନ୍ଦ କରି ଶୋଇଲୁ, ବାପା ମା ଆମେ ଛୁଆ
କୋଉଟା
ବନ୍ଦ ଶୋଇଲୁ, PW6 କହିଲେ।
with the accused. On one Saturday in the month of Magho, in the relevant night, myself, my mother had slept in our room with the small kid, and my husband had slept in the middle room. Middle room and clearly say jota. With हाँ नहीं नहीं आउ से ता पाखरे आउ जन सोईची माने 5 वर्ष झियो को नेकिन से सोईची ना माने गोटे रूम रे हाँ गोटे रूम रे PW हाँ गोटे रूम रे PW6 अछि तार मा अर्थात से जो अपेलेंट रो वाइफ अछि एवं ता सहित गोटे छोटो छुआ अछि मझी रूम रे डिसीज्ड अछि ता सहित गोटे 5 वर्ष रो झियो राइट ता ना होची ना होची वर्षा फ्रंट रूम टारे सोईची PW4 हला at that time I heard sound of opening door of my house. I thought that my husband and my brother-in-law might have opened the door, for which I did not wake up. At that time I heard halla of my husband तामने सेटा बोधे जितले बिभिंग करथिला से जो accused जे भी हेतिबो से ताकू at that time I heard halla that such as bopa ma busi dala. On hearing such cry I rose to the bedroom माने adjacent मझी room को आसिला and found my husband was having bleeding injury on the belly and the accused was decamping from the spot holding knife in his hand. तापरे से साउट करची साउट कला परे अटेंशन आसीची आरो जो PW4 रो हां
सो सेटे दीटा डोर अछि गोटे डोर वाला इनिशियल D1 टा वुडन डोर अछि फर्स्ट तापर जो मझी जो दीटा डोर अछि रियाको सेटा डोर नाही गोटे टाटी अछि गोटे प्लेन अछि कि नाही डोर बिकॉज़ इट वाज अंडर कंस्ट्रक्शन जोटे क्रॉस एक्सटेंशन रे D6 कहि जेतो सो लास्ट एकेन आउट वुडन डोर हला आको जो माने D6 रे सोइतले से रूम क्रॉस करि गेल पछडू जोटा
नहीं सीए
गोटे बाटे D1 बाटे आछि
हाँ नहीं नहीं आपण जो पछपट देकिन जीवार
चांस
नाही ना
तो ओनली D1 बाटे ही आछि
रूम रे हाँ जो रूम रे पैडी अछि जो रूम रे D1 देखैचंती एवं जो रूम रे PW4 सेही पटे आसीची एवं सेही पटे जाईची हला एटा होची जे भी ये करची तेनु
एंट्री एंड एग्जिट इज
वन एवं आपणकर एई रूम रु ही बोधे से जो ब्लड स्टेन करिका एटु जहा मिलथिबो एई रूम रु मिलथिबो आउ तार जदि एविडेंस आसुची मते आसी कि कहिला उठेला माने ता माने इयाडू को आसीची से
फेर जाई
ता परे से जाईचंदी तापरे से जाईकिनी दांडक वाट पाखरे पड़ची सेते बेलकू अक्यूज्ड सिंगल ब्लो नहीं नहीं मो पोस्टमार्टम
अच्छा एठी डॉक्टर पको PW5
हां
पेज 64 54 मतलब
ଏଇଟା ମୁଁ ପଢିକି ବୋଧେ ହେଇଥିବ କାରଣ ଏ ଯୋଉ
Measure is what?
ହଁ ନାଇଁ ସେଇ ଷ୍ଟାଫ୍ ଟା ଗୋଟେ ମାରିକିନି ଏ ଯୋଉ ପଡିଲାନି ସେ ପୁଣି ଯୋଉ ଦୁଆର ପାଖରେ ପଡିଲା ସେ that may be the cause of this second one. ହଁ second and peritoneum ତା ପର ପେଜରେ ଯୋଉ ପେଜରେ କହିଛି more details of the description of the injury ପାଇଲେ ନା 55 ରେ ପାଇଲେ ତା ପର ପେଜଟା
Wall one stab wound.
50 हाँ सही पेजଟା 55 पर हाँ सही राइट ये जो एक नंबर more detail 8 এটা more detail one stab wound of size 1 so এটা হচ্ছে সেই যে মেন ইনজুরিটা
Main.
তারপরে ହେଲା পেরিটোনিয়াম ওয়ান সো রপচর এটা এসে গলা তারি কনসিকুয়েন্স থার্ডটা হচ্ছে যে ল্যাসেরেটেড wound সেটা 1 cm just মানে প্রেজেন্ট অফ দি লেফট সাইড মার্জিন অফ দি on the in mouth মানে ସେ ପଡିଲା ବେଳକୁ ହଁ ମୋ ପାଟିଛି ସୋ থার্ড ইঞ্জুরি সে মধ্যে କହିଛି থার্ড ইঞ্জুরি ওভার দি টং এটা ଯୋଉ ପଡିଛି ଜିଭ ଯୋଉ ଇଏ କରିଛି caused by the tongue bite of the teeth of the disease right so one injury
ଗୋଟେ
One step.
one step
ମାରିକିନି ଅର୍ଡିନାରଲି ଭିଜୁଆଲାଇଜ କଲେ one blow abdomen ରେ ମାରିକିନି ଯିଏ ଆସିଥିବ ସିଏ ପଳେଇଥିବ ତାପରେ ଇଏ ପାଟି କରିଥିବ ପାଟି କଲା ବେଳକୁ ୱାଇଫ ଉଠିଥିବ ହେଲା କି ୱାଇଫ ଆଗରେ କହିଛି କିଏ ଗୋଟେ ମାଲୋ ବାପାଲୋ ଭୁସି ଦେଲା ତାକୁ କହିଛି ତାପରେ ୱାଇଫ ଆସିକିନି ଦେଖିଲା ପରେ ସିଏ ପାଟି କରିଥିବ ସେତେବେଳକୁ ଆଉ
ଯିଏ ପଶିଛି ବାହାରିଛି ସେ ତାକୁ ସେ PW4 ଉଠିନି ବି
ଆଁ
ପଶିକି ବାହାରିଲା ଭିତରେ
ନା ନା
PW4 ଉଠିନି।
PW4 in deep slumber ହେଲା ତାପରେ ସିଏ ଉଠିଛି ତାର ଏଭିଡେନ୍ସ ହଉଛି ମୋ ଭାଉଜ ଯେତେବେଳେ
ପାଟି କଲା ପରେ
ହଁ
ଏବଂ
ସେତେବେଳକୁ
ଗଲା
ଆଉ accused
ବାହାର ଲୋକ ମୁଁ ଚେସ୍ କରିନି ଚେସ୍ ବାହାର ଲୋକ
ହଁ ସେତେବେଳକୁ ଆକ୍ୟୁଜ ଯିଏ ଗୋଟେ ବ୍ଲୋ ଦେଇ ଫସି ଯାଉଛି ସିଏ ଆଉ ଥିବ ଦୁଆର ବନ୍ଧ ପାଖରେ ସେ କହୁନି ମୁଁ ଦୁଆର ପାଖରେ ମୁଁ ଦେଖିଲି ଦୌଡିକି ପଳେଇ ଯାଉଥିଲା ଆମ ରାସ୍ତା ଆଡକୁ ନା କଣ ଇଏ ଦ୍ୟାଟ ଇଜ ଏଭିଡେନ୍ସ ଅଫ PW4
MO is also not important.
ଏଗୁଡା ଦ୍ୟାଟ ଇଜ ଦି ରିଜନ ହ୍ୱାଇ ଦି FIR ରେ ଯୋଉ ଲଜ୍ ହେଇଛି କେହି ଦେଖି ନାହାନ୍ତି ସନ୍ଦେହ କରିକି ଦେଖା ହେଇଛି ତାପରେ ଏଗୁଡାକ
evidence
ଡେଭଲପ
ଗୁଡା
କରି ଇଭେନ ଇଫ
161 ବି
160
ନାହିଁ।
ହଁ 160 ପ୍ରଥମ 161 ଟୋଟାଲ ନାହିଁ
ସେକେଣ୍ଡ ବି କଭର ଅପ ଇଏରେ ଆସିଛି ବଟ
ହଁ।
ନଟ
ଇଫ ଆଉ ବାକି କଣ ଏଭିଡେନ୍ସ ରହିଲା
ଆଉ ରହିଲା PW8 ଟେ ଦେଖିଲ
PW8 ଟା କିଏ ଆଚ୍ଛା ଆଚ୍ଛା ହଁ ସେଇଟା ପଢ
page 64 my lord.
Maya Das
Yes,
okay
ma'am.
apparent wife
Page 64. Deceased Babula Naik being the husband of my daughter,
was my son-in-law
was
ସେ ଗୋଟେ
son-in-law.
ସେଣ୍ଟେନ୍ସ ରେ ଯାଇଛି ଗୋଟେ ଷ୍ଟପ୍ ଟା ହେଇଯାଇଛି ବଟ୍ ଠିକ
The
ଅଛି
informant is the brother of deceased Babula Naik. Accused Champadas is my husband. I am blessed with 5 sons and 1 daughter. Vishnu alias Lalita Naik is my daughter, who was married to deceased Babula Naik. My husband, being addicted to the liquor, was subjecting physical assault and torture.
subjecting me
Me physically assault and torture.
physically କୋଉଠି ଲେଖା ହେଇଛି physical assault
Physical
subjected
assault.
me physical assault and torture yeah
Stop. Occurrence took place more than 2 years back. 1 month before the occurrence, I was staying in the maternal home of my daughter at Bali Padar with the deceased and his family members. As the accused, after assaulting me, gave threatening to take away my life. Full stop. I came away and resided in the house of my son-in-law 1 month before the occurrence. Paragraph 2. In the relevant night, myself and my daughter had slept in one room of the house of the deceased, and the deceased had slept in with my grandson in another room of the house. At about midnight 12 p.m., my son-in-law deceased raised halla stating such as "Moti kiye maridala mori gali bappa ma." I woke up hurriedly and when rushing to his room, first of all, I found the stomach of my son-in-law had already been protruded in interesting to the outside. At that time, I found that my husband running away from the room of my son-in-law after assaulting him with a knife. Seeing the critical condition of the husband,
Of the
I
disease.
of the condition of the deceased, I became unconscious. First of after I regained my sense, I found at 7 a.m. the dead body of my son-in-law in the house, and I ascertained that the dead body of my son-in-law was brought from the hospital. Previously, there was a altercation between my husband and deceased Babula, as my husband was insisting to take me back to his house, and the deceased did not leave me from his house to avoid physically assault and danger to my life by the accused. Cross-examination matter, paragraph 3. I was I was given in the marriage to the accused in the village Narendra Pur, and my daughter was given in Maria marriage
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 mo kଣ marriage?
marriage sorry, marriage in village Balipada. The bus full stop. The bus fare from Balipada from Narendra Pur is about Rs 12 rupees. My daughter was married to the accused since 9 years back. My daughter is the eldest of all of my children. At present, my elder son is about 14 years. Due to physical assault committed by the accused, I came away to my daughter's house with my eldest child, and my other sons were residing with the accused in his house. 2 days after my departure, the accused brought my son and left them in the house of my daughter with me. Myself and my husband were pulling on well with the family members of the deceased after the marriage till the date of occurrence. My son-in-law used to visit my house at Narendrapur to sin, and the accused was assaulted me, but not allowing my daughter in to visit out house after the marriage to see me. Paragraph 4, my lord. The occurrence house is 15 cubits in length and 4 cubits in 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 width, consisting of 3 rooms having cement room, small wooden. The doors of the third house previously exited exit before the construction of Pakka house had been kept on the door of the Pakka house at relevant house. The small wooden doors were just uh, le- uh, leaning against the door of the Pakka house of a house having no latches at the relevant time. As the wooden doors were leaning against the doors of the Pakka house, it was access,
Accessible.
acceptable to anybody else at that time. It was a it was dark at the time of occurrence, and hearing noise of my son-in-law, I woke up and ran to his room. Due to darkness, I could not uh, see see
I could not see injuries
in
or
son-in-law in the room. In the room,
injuries of
but
my
I could not feel the injury on my son-in-law
but
by
I could
touching
feel. I
injury.
could feel. ଦେଖି ପାରିଲିନି
Yes, ma'am.
ଅନ୍ଧାର ଯୋଗୁ ମୁଁ ଦେଖି ପାରିଲିନି
Yes.
କିନ୍ତୁ ମୁଁ feel କଲି the
Touching.
injuries of my son-in-law touching the body in my hand
And in
in the midst of darkness. Yes.
But when I touched the body of my son-in-law, I could notice the injury on his his person by putting my hands out, hands for which I become senseless at that time. Thereafter, I could not know anything what had happened and who had removed my son-in-law to the hospital. I was examined by the police in connection with this case. Paragraph 5, page 66. I, it do not remember if I had stated before the police that midnight 12 midnight my son-in-law raised halla stating such moti kiye mari dalare, and that I woke up hurriedly and uh, ran to his room and found that the stomach my son-in-law had already been uh, put running away from the room after assaulting my son-in-law with a knife, and that I might have stated to the police that seeing the occurrence, I become unconscious. Full stop. It is a not a fact that the accused was never subjecting me to physically assault and torture, taking liquor, and that I am deposing false case against him. It is a not a fact that the accused had not assaulted the deceased by means of a knife causing his death, uh, and at at the instance of my daughter, I am implicating the accused with this case, and that I was never residing with my husband along with my children, and that I was along along staying with my daughter, leaving my husband and children at Narendrapur. That's the delivery.
But a 100-watt electric bulb was there. But a 100-watt bulb would see. Ah,
Debris.
even. Madam. Dividend.
Page ମାନେ paragraph last ଆଡକୁ paragraph at the relevant time place say PW 6 minute at the relevant time a kerosene db was burning in the occurrence page 29 minute 1 2 3 last addku 59 minute 59 paragraph 1 ର last addku
Time हाँ one kerosene divided
at the relevant time kerosene db was burning in the
was burning is the occurrence. Mr. Das, ये जदि आपणकर केस होउची जे गोटे नोन पर्सन आसी डिसीज्ड को मर्डर कला कोनोसी कारण पाई मोटिव जा थाउ से छाड़ी जानी बेली ता सासु को ये कला एवं ही चूजिंग ए टाइम dead hour of the night to come commit the crime and escape from the spot. Whether that person would take all these steps to conceal or hide his identity or not.
Definitely.
Okay. Number two, whether it is expected that after committing the crime he will remain there and after the other persons of the house got up, then he will start to identify. So that is the reason why in the FIR it is rightly said that nothing has been ame sandeh korchu. Then the story has been developed during evidence.
Because 161 is also suspect.
161 also suspect. Dita ka ame dekhiluni 161 dita ka sabu dita ka suspect.
Any other
Exhibit 2 matter. Can have a we don't have the exhibit 2 matter. Seizure list matter.
ठीक है रोज exhibit टा बाहर करे 2 टा कौन कहउछन
Leading to discovery जो सीज वाला नाइफ टा
ठीक है रोज exhibit 2 टा चार्ज शीट टा तापर FIR माने प्रकार से अरेंजमेंट करूछंती पेपर बुक को माने किछि तार किछि पत्ता गता मिलुनी 39 हां नहीं exhibit 2 माने
ये तो
এটা বল আর নাইফ রুচি দিয়েছি
সেটা কি কইছি
সেটা আইও
আইওর এভিডেন্স
রে
जैसे एग्जिबिट आपण कहउछ ने हमको एग्जिबिट देखिया पई
हां काई कहउची
हां
से जो नाइफ टा सीज कला एक्चुअल को स्पॉट रो सीज कला सेटा सेते माने को जागर सीज करला
वो नाइफ टा को छाड़ दी जाईसला की
सेटा सेटे में
ठीक है
नाइफ टा से माने वसे जो पैडी बैग रू भाग को जो कहउची from the house of the deceased or from the house of the
27
accused 27 रे पिडोल विटनेस होज मेलर पिडोल 1
हां अच्छा से जो पेपर बुक जे तयारी करछि से बाबू टे डाकियो दादार कथा केमिति तयारी तार गोटे आम एक्जिबिट लिस्ट टा मारला माने तापर आसी जीवा कथा एवं रहिबा कथा एक्जिबिट 1 click kale 1 hour bari
Data queue to no apply cost, they have not guided it.
properly guide କରିକି ନା oda
So this is exhibit of exhibit 2 that
ହଁ ଯୋଉଟା ଲେଖା ହେଇଛି ଗୋଟିଏ
picture size loogie.
ରକ୍ତ ଲାଗିଥାଏ ଆଉ ଗୋଟେ ହଉଛି ଭିଜା ମାଟି ନମୁନା
Kerosene
ମାଟି କିରୋସିନ ଡିବି ଏଇଟା ତ ରହିଲା ଏଇଟାର ତ କିଛି ନାଇଫ ସିଜ୍ ହେଇନି
exhibit to the मतलब only taunt to हो
exhibit 2 ରେ ରକ୍ତ ବିଷୟ ଲାଗେ। 3/1
କୋଉଟା କହୁଛନ୍ତି ତାକୁ ଏ ବାବା ସେ ଯୋଉ ଅରିଜିନାଲ ଟା ଦେଲ ହଁ
ସେଇଥିପାଇଁ that is how the whole thing is different. LCR of page marking ହେଇନି ଆଉ book marking ମାର୍କେଟ ନାଇଁ ସେଇଟା ହେଇଛି
मतलब
exhibit 2
मतलब
exhibit 2 exhibit Flying Babylon Adi Guru Police electricity Sankontani Sango Sister Rocky Sango Poste Time Polaya
ସେଟା ଗୋଟେ ମାନୁପୁଲେଟ କରୁଛନ୍ତି ଦେଖୁଛନ୍ତି ଆଉ ସିଏ କହୁଛନ୍ତି ସେଇଟାକୁ ନେଇକିନି ସିଏ ତାମାନେ ସେଇ ଘରେ ତାମାନେ ଯୋଉ ଛୁରୀଟାକୁ
ସେ କହୁଛନ୍ତି ସେ ପ୍ୟାଡି ବ୍ୟାଗ
ଛୁରୀଟାକୁ ପ୍ୟାଡି ବ୍ୟାଗରୁ ଦେଖେଇଛନ୍ତି ତାପରେ ତାକୁ 27 ରେ ରିକଭରି କରେଇକିନା ଆଣିଛନ୍ତି ତ
and MO was also not produced in court method.
ସେ ଲାଙ୍ଗୁଏଜ ରୁ ତାମାନେ ଆପଣ ଯଦି ସେଇ ଏଭିଡେନ୍ସ ଟା ଆକ୍ସେପ୍ଟ ହବ ତାମାନେ ସେ ମାରିଲା ପରେ ସେ ମଝି ଘରେ ଯୋଉଠି ଗୋଟେ ଲୋକଟା ଶୋଇଛି
ଫାଷ୍ଟ ରୁମ ରେ
ଫାଷ୍ଟ ବା କହୁଛି ସେ ରୁମ ରେ ଗୋଟେ ଲୋକ ଶୋଇଛି ତାପରେ ସେଇ ରୁମ ଭିତରେ ଯାଇକିନି ସେ ଯୋଉ ଆ ଭିତରେ ନୁଚେଇବ ଇଆଡେ ସିଏ ପାଟି କରୁଥିବ ମାରିଗଲି ସେ ରହୁଥିବ ସେ
ତା ସାକ୍ଷୀ କିଏ ଏଇଠି ଏକ୍ସାମ ହେଇଛନ୍ତି
କୋଉଟାରେ
27
PW1
PW1
ସେମିତି
PW1 ତ ତା ଏଭିଡେନ୍ସ କିଛି କହୁନାହିଁ ଓ ଆମେ PW1 ଟାକୁ ଆମେ ଦେଖିଲୁ ଆମେ ଯାଇନୁ ଆଚ୍ଛା ଲେଟ୍ ଅସ୍ ସି
ପଢିଦେଲେ PW1 ର କଣ ଦେଖିବା
page 45 ମାନେ listen I know the informant I also know the accused standing in the dark deceased Babula Naik was known to me who met his death on 21/1/2006 on a Saturday at about 12 midnight. In the following morning of the occurrence, I heard from the villagers that someone killed Babula Naik in the night in his house. Hearing about this, I went to the house of the deceased, who happened to be my paternal uncle. On my arrival, I heard that accused has already been caught by the police. On my arrival, I found the police
taking the accused to
the police station. First of all, at that time, before taking to the police station, the accused admitting to have killed the deceased Babula Naik with a knife told that he had kept concealed the knife under the paddy bags kept in in his
his
house, and he had removed the ball which was burning at the relevant time, kept the same near the knife under the paddy bags. First off, so admitting the accused
led us
led us to the police
to the place
to
of
the place
concealment,
of concealment and gave recovery of knife and the
the
ball.
ball.
The police reduced the statement of the accused to writing and put my signature on.
ନାଇଁ, ତାପରେ ମାନେ ସେ ବଲ୍ବ ଟା କଣ ଆଗରୁ ରିମୁଭ କଲା ନା ସେ ମର୍ଡର କଲା ପରେ ସେ ବଲ୍ବ ଟା ଖୋଲିଛି ସେ ରୁମ ରୁ ତାପରେ କାରଣ ବଲ୍ବ କୁ ସେଇଠି ଲୁଚେଇଥିଲା ପରା କହୁଛି ସେ
Yeah.
ସେ ବୋଧେ ଗଲା ବେଳକୁ ବଲ୍ବ ଟା ଖୋଲିଦେଲା, ମର୍ଡର ସରିଗଲା, ତାପରେ ବଲ୍ବ ଟା ଖୋଲିଲା,
ଖୋଲିଲା
ତାପରେ
ବଲ୍ବ କୁ ଆଉ ଛୁରୀକି ଦିଟା ଯାକ ନେଇକି ସେଠି ଲୁଚେଇଛି ସେ କହୁଛି। ଏପରା କହିଲା he had removed the ball which was burning at the relevant time and kept near the same near the knife or under the paddy bag। ତାମାନେ ବଲ୍ ଟାକୁ ବି ସେଠି ରଖିଛି ସିଏ। So exhibit 1 is that's exhibit 1 ଟା ଦେଖିବା କଣ ହେଇଛି।
Statement.
ନାଇଁ
Accused statement.
accused ମାନେ ଯୋଉ
Confession statement.
ହଁ 27 ତ
ନାଇଁ ନାଇଁ ସିଜିୟର ଲିଷ୍ଟ ର ଏଇ ଯୋଉ ଛୁରୀର ଯୋଉଟା ଆମେ
Accused
ଦେଖିଥିଲୁ।
two.
Exhibit 2.
Exhibit 2 ଟା।
ଛୁରୀ ଲୁଚେଇ ରାତି ସେଇ ଯାଏ ଆପଣଙ୍କୁ ଦେଖେଇ ଏଇଠି କହିଲାନି ସେ ଇଏ ବଲ୍ବ, ଏଇଟା ବଲ୍ବ କହିଛି। ମୁଁ ଜ୍ୱାଇଁ ବାବୁଲା ନାୟକ ବସିଥିବା ଓ ତାଙ୍କ ବାରି ଘରୁ ଖୋଲିଥିବା ଇଲେକ୍ଟ୍ରିକ ବଲ୍ବ ତାଙ୍କ ଦାଣ୍ଡ ଘର ଧାନ ବସ୍ତା ଭିତରେ ଲୁଚେଇ ରଖି ଦାଣ୍ଡ ପଟେ ଧାଇଁ ସେଠାରୁ ପଳାଇ
କଣଟା ଜବରଟା
ଜବରଟା property seized, ଏଇଟା ତ ଏଇଥିରେ ସେ କରିଦେଲା ଆଉ କଣ ଆଉ ଏଥିରେ ସବୁ ଲମ୍ବେଇ ଦେଲା। ଏଇଠି ନାହିଁ property seized as per column 13 reverse ଏଇଟା ଗୋଟେ ଲୁହା ଛୁରୀ ଯାହାର ମୋଟ ଲମ୍ବା ଏତିକି, ଗୋଟିଏ 100 watt electric bulb।
100 watt ବଲ୍ ଟା ବି ଯଦି ହେଇଥିବ ଏଇଟାକୁ ସିଏ ଆଗରୁ ଜଣେ ରିମୁଭ କରିଥିବ, ଯଦି ବି ଆଟଲିଷ୍ଟ ରିମୁଭ କରିଥିବ, କାରଣ ସୋ ଦ୍ୟାଟ ତାକୁ କେହି ନ ଚିହ୍ନି ପାରନ୍ତୁ ବୋଲି ଯଦି ସେଟା ଜଳୁଥିବ ତାହେଲେ ରିମୁଭ କରିଥିବ। ଦେନ୍ ତାପରେ ମର୍ଡର କଲା ପରେ ଓବିୟସଲି ଆମେ ଯଦି ଦେଖିବା ମର୍ଡର କଲା ପରେ ବଲ୍ବ ଖୋଲିବ, ତାପରେ ପୁଣି ଯିବ ସେଠି ରଖିବ।
Before that, entering the room of the middle room, that ball was removed and kept in the paddy bag. Then murder, and then again the knife was brought in the.
ତାମାନେ ପ୍ରୋସିକ୍ୟୁସନ ଷ୍ଟୋରି ହିସାବରେ ଦେଖାଯାଏ ତାହେଲେ ଏକ୍ୟୁଜ୍ଡ ତା ମୁହଁ ନ ଦେଖେଇଲା ପର୍ଯ୍ୟନ୍ତ ସେ ଜାଗାରୁ ଯାଉନାହିଁ।
ସମସ୍ତେ ଘର ଲୋକମାନେ ଆଉ ଉଠନ୍ତୁ, ଆଉ ସେମାନେ ଉଠିଲା ପରେ ମୁଁ ଏଠୁ ଖସିବି, ତାହେଲେ ସେମାନେ ଦେଖିବେ ମୋ ବିରୁଦ୍ଧରେ ସାକ୍ଷୀ ଦେବେ। Whereas in the FIR it is totally silent that anybody has marked the
That is badly investigated, badly planned, badly recorded.
prosecution case as follows. This is Baba Simon accused. So, that was to see person. See the yes. So, ଆପଣଙ୍କର ଡିଫେନ୍ସ ବି କଣ ମାନେ ଟୋଟାଲ ଡିନାଲ ନା କଣ ନେଇଛନ୍ତି ନା ମିଛରେ ଖାଲି କହୁଛନ୍ତି?
Evidence to nation
Hmm?
one is
Eh?
page 76.
ଗୋଟେ ସାକ୍ଷୀ ଦେଇଛନ୍ତି ସଫେଇ
Yes,
ସାକ୍ଷୀ
sir.
କୋଉ ପଏଣ୍ଟ ରେ?
76 madam.
ଆଉ ସେ ଯୋଉ ତାଙ୍କର ଯୋଉ ମାଡ ଫାଡ ହେଇଥିଲା ଆସିକି ରହୁଛନ୍ତି ସେଇ ବିଷୟରେ?
हाँ सेटा से ता नहीं करजे मु मारनी किछ करनी
निजे evidence
ନିଜେ
ଦେଇଛନ୍ତି?
evidence?
चप्पा
Dangerous.
I have 5 sons and 1 daughter. My only daughter was given in marriage once. So at the relevant time, my 2 younger sons were residing with me, and I was maintaining them on daily wages. My wife used to go to the matrimonial house of my daughter frequently. My wife was never taking care of me and my children at any time. My wife was having illicit relation. Her person was frequently leaving my house. Nature of daughter is same to that of her mother, for which so my son-in-law used to assault most of the time. Despite my several legal, my wife is not joining with me in my house at the time. It's not a fact that I had committed so and so. The knife.
My wife and daughter committed the murder of the deceased, as he was always protesting against them, against their conduct in keeping English relationship with other person.
ସେ ଘରେ କାହିଁ ତାହେଲେ ତ ରଖୁଥିଲା ଆଣିକି ଯଦି
Thereafter committing murder of my
ମାନେ
son-in-law.
କିଛି ପ୍ରୋସିକ୍ୟୁସନ ଏଭିଡେନ୍ସ କୁ ଆକ୍ସେପ୍ଟ କରିଛି ଯେ ସେମାନେ ଆସି ଏଠି ରହୁଥିଲା ବୋଲି ଆଟଲିଷ୍ଟ ଆଉ my wife was not joining me ସେଟା ମଧ୍ୟ ପ୍ରୋସିକ୍ୟୁସନ କେସ୍ so ବାକି ତାର
Defense.
He said that thereafter I'm quite innocent, no way connected with the murder. Set up by
Se likhto
my
pato
wife
mana
and-
kotti mu nei
Huh?
mu PIP करनी mu not a fact तारो defense के होती करछि मना कर deny करछि
JCRLA number 96 of 2008, the appellant Shapadas faced trial in the court of Learned Additional Sessions Judge Bhanjnagar, Ganjam, in Sessions Trial number 41 of 2006 for offense punishable under section 450 and 302 of the Indian Penal Code on the accusation that on 22/1/2006 during midnight at Bali Padar on Khodala Sahi, he committed house trespass by entering into the house of the deceased and committed his murder. The Running Trial Court, by judgment and order dated 24/11/2008, found the appellant guilty under both the offenses and sentenced him to undergo imprisonment for life and to pay a fine of rupees 1,000 in default of payment of fine, to undergo RI for 6 months under section 302 of the Indian Penal Code, and to undergo RI for 2 years and to pay a fine of rupees 500, in default to undergo SI for 2 months for the offense under section 450 of the Indian Penal Code, and both the sentences were directed to run concurrently. Stop. The prosecution case, as per the first information report, bracket exhibit 6, lost by Bulu Nahak, bracket PW4, the younger brother of the deceased Babula Nahak, on 22/1/2006 before in Baliguda police station, Balipadar outpost, is that on 21/1/2006, a video show was going on in the backyard of their house, and he was watching the video. And during at midnight at about 12 o'clock, the village children intimated him that somebody had stabbed the deceased, his deceased brother, and fled away. PW4 rushed to his house and found the deceased was lying with stab injury on the abdomen in the entry point of the house, and he was not in a position to talk. The wife of the deceased, namely Vishnu Nayak alias Lolita Nayak, bracket PW6, he asked his sister-in-law, who is the wife of the deceased, namely Vishnu Naik alias Lalita Naik, bracketed PW6, who told him that they were sleeping inside the house after closing the door, and during the midnight at about 12 o'clock, the deceased called PW6 and told that someone had stabbed him and fled away. PW4, along with his father, brother-in-law Govind Naik and others, shifted the deceased to the government hospital of Baripadar, but the doctor, examining the deceased, declared him dead. It is further stated in the FIR that the deceased had married to the daughter of the appellant since 7 years prior to the occurrence, and they were blessed with a son and daughter. PW8 Mayadas is the wife of the appellant, and the appellant created disturbance with PW8, assaulted her, for which PW8 came to reside in the house of the deceased about a month prior to the occurrence. The appellant came to the house of the deceased and created disturbance with the deceased. And over this issue, it was suspected that in the occurrence night, while the deceased, along with his wife and son, were sleeping, at that time, the appellant entered inside the house with a sharp cutting knife, with a knife, and stabbed the deceased. And prior to the date of occurrence, the appellant had threatened the deceased as well as his wife, bracketed PW8, with dire consequences. PW4 made oral report before the ASI of police Bali Padar outpost, which was reduced to writing, and thereafter it was sent to the officer in charge of Guda police station for formal registration, and accordingly the OIC Buguda police station registered Buguda PS case number 9 dated 22/1/2006 under section 457 302 of the Indian Penal Code and took up investigation of the case. During course of investigation, PW11 visited the spot, prepared the spot map Exhibit 7, seized the bloodstain lungi, bloodstain earth, sample earth, and one DVD from the spot as per seizure list Exhibit 3, conducted inquest over the dead body of the deceased at Balipadar Government Hospital and prepared inquest report Exhibit 8 and dispatched the dead body for post-mortem examination and arrested the appellant on the same day. It is stated that while in police custody, the appellant confessed his guilt and led the police party and other witnesses to the front room of the spot house and gave recovery of one knife and 100-watt electric bulb, which were kept concealed under the paddy packets, and the same was seized as per seizure list Exhibit 2. The wearing apparels of the appellant were seized as per seizure list Exhibit 11. The appellant was sent to Medical Officer Buguda PSC for collection of nail clipping, and the same was seized on production by the constable as per seizure list Exhibit 12. And the wearing apparels of the deceased and a bottle containing sample blood of the deceased were also seized on production by the constable after post-mortem examination. The DPD which was seized from the spot room was released in the Jima of Bulu Naik bracketary PW4. As per Jimanama Exhibit 16, the IO bracketary PW11 made a query to the doctor who conducted post-mortem examination regarding possibility of the injury sustained by the deceased by the seized knife, and received the query report. The exhibits were sent to RFSL Barampur through SDGM Anjanagar for chemical examination, and he received the post-mortem report, and in the as he was transferred, he handed over the charge of investigation to SI Purnachandra Mahapatra. He has not been examined, who on completion of investigation submitted charge sheet under section 450 and 302 of the Indian Penal Code. The defense plea is one of denial. However, the appellant being examined himself as DW1 and stated that his wife bracketed PW8 was having illicit relationship with other persons and was frequently leaving the house, and the character of his daughter bracket PW6 was also similar. And as the deceased was protesting against the conduct of PW6 and PW8, they have committed the murder and falsely implicated him. In order to prove its case, the prosecution examined 11 witnesses. So and so exhibits were also proved. The London trial court, after assessing the evidence on record, came to hold that the prosecution has proved both the charges and accordingly found him guilty. The London counsel appearing for the appellant submitted that there are no eyewitnesses to the occurrence and the case is based on circumstantial evidence. And though witnesses like PW4, PW6 and PW8 have stated, PW8 से विषय तो किसी कहूँगा मैं नहीं जो दौड़ी किन जीवा विषय है PW4 and PW6 have stated to have seen the appellant running away from the sport house towards the chuck, but the same is not there in the first information. Both also PW8, but the same doesn't find place in the first information report. And also in the statement recorded under section 161 CRPC, and it has been subsequently developed just to falsely implicate the appellant in the crime. He argued that the first information report clearly indicates that nobody had seen who committed the crime and about the identity of the person, and they suspected, it was suspected that the appellant might have committed the murder of the deceased. The London counsel further argued that when the appellant was a known person to all these three witnesses, that is PW4, PW6 and PW8, and it is alleged that he has come during the midnight to commit the crime. It was expected of him to conceal the identity and to leave the spot after committing the crime as soon as possible. And in such a scenario, the evidence of these three witnesses that they were able to mark the identity of the appellant while leaving the spot, and the appellant is not at all believable. The Land Council submitted that though the prosecution case is that at the instance of the appellant, basing on his statement recorded under Section 27 of the Evidence Act, one knife and one valve was seized from the paddy stacked in the first room of the sport house, where PW4, the informant, was stated to be sleeping, but it sounds very difficult to accept that the appellant, after committing the crime, would stay there for some time and remove the electric bulb, and so also conceal the same along with the knife, and thereafter leave the spot. The Land Council submitted that it is apparent that a case has been foisted against the appellant, and the circumstances proved by the prosecution are not clinching and do not inspire confidence, and they do not form a chain so complete so as to unerringly come to the conclusion that it is the appellant who has committed the crime, and therefore it's a fit case where benefit of doubt should be extended in favor of the appellant. The Land Council for the state, on the other hand, supported the impugned judgment and argued that there was motive behind the commission of the crime, inasmuch as the appellant was not allowing PW8, the wife of the deceased, to the wife of the appellant. Well, the deceased was not allowing PW8, that is the wife of the appellant, to join the appellant, who was staying there, um, stated to have been assaulted by the appellant. And there was previously, there was over this issue, there was disturbance between the deceased and the appellant. And the evidence of these three witnesses are consistent that they had seen the appellant decamping from the spot, and at that time the deceased was also had also sustained bleeding injury on his abdomen, which uh, proves the prosecution case that after committing the crime, the deceased, the appellant, was leaving this spot house. The Land Council further submitted, further argued that the seizure of the knife, which was the weapon of offense, was sent for chemical examination, and the doctor and the chemical examiner has noticed human blood on the same, and it was seized from the paddy stacked in the first room of the sport house. And therefore, the chain of circumstance is complete, and the appeal should be dismissed. There is no dispute that the case is based on circumstantial evidence, and the principle relating to the appreciation of case based on circumstantial evidence is well settled in case of so and so. PW 6 is the widow of the deceased, and she has stated that the appellant was a habitual drunkard, and he was subjecting her mother, bracketary PW8, to torture and harassment under the influence of liquor, for which the deceased brought her, and she was staying with them in their house, for which the appellant bore grudge on PW8. PW6 further stated that on the night of occurrence, she, along with PW8, had slept in one room with her small kid, and the deceased was sleeping in the middle room of their house with a 5-year-old daughter. And at the relevant time, she heard the sound of opening of the door of the house, and she thought that the deceased or her brother-in-law, bracket PW4, might have opened the door, for which she did not wake up. And at that time, she heard halla of the deceased, Boppa Ma Bhusidela. And hearing such halla, he rushed to the bedroom of the appellant and found of the deceased, and found the deceased was having bleeding injury on the belly, and the appellant was decamping from the spot, holding a knife in his hand. She shouted, directing PW4 to catch hold of the appellant, as he had stabbed the deceased with a knife. Stop. PW4 chased the appellant to catch hold of him, and when she caught hold of the deceased, as he was in severe pain due to the bleeding injury on her belly, comma, he was comma kar do. So he was holding at that time he was holding, and PW4 returned back home and couldn't catch hold of the appellant. She further stated that at the relevant time, when kerosene DB was burning in the occurrence room. She further stated that in that relevant night, PW4 was sleeping in the front room of the house. From the evidence of PW6, it appears that when she woke up hearing the halla of her husband, not only she found her husband in a bleeding condition, receiving injuries on the abdomen, but also the appellant decamping from the spot. And she drew the attention of the informant, and then the informant, being unsuccessful to catch hold of the appellant after chasing, returned back home, and thereafter the deceased was shifted to the hospital where he was declared dead. And then the first information report was lodged. On the basis of the oral report made by PW4. If PW4 either himself had seen the appellant escaping from the spot, or he was informed by either PW6 or PW8 in that respect, it was expected of him while lodging the report before the SI of police of Balipadar outpost to mention the same. But most surprisingly, there is no mention in the first information report that any of the family members of the deceased had seen the appellant leaving the spot room in the occurrence night. Rather, it is mentioned that somebody had stabbed the deceased and fled away through the front door of the house. And it was suspected that the appellant might have committed the murder of the deceased. In the case of Ramkumar Pandey versus State of Madhya Pradesh, the Honorable Supreme Court held that no doubt an FIR is a previous statement which can, strictly speaking, be only used to corroborate or contradict the maker of it. But since in that case it was the FIR was lodged by the father of the deceased, to whom all the important facts of the occurrence were known prior to the lodging of the FIR, as they were communicated to him, he would have certainly mentioned it in the FIR. The Honorable Supreme Court further held that omission of such important facts, affecting the probabilities of the case, are relevant under Section 11 of the Evidence Act in judging the veracity of the prosecution case. There is no dispute that the evidence which was adduced by the prosecution during trial, that the appellant was decamping from the spot in the occurrence night, was no doubt a very important fact. And since the same is not mentioned it creates a doubt in our mind that the story has been subsequently concocted to implicate the appellant in the crime. And nobody was aware as to who committed the crime, and the family members of the deceased were only suspecting the involvement of the appellant in the crime in view of his dispute with PW8 and the deceased. If this part of the evidence, acha se jo homicidal death ro acha seta pratham ru tige lekhi debe. Acha at this stage it is pertinent to mention that the doctor who has conducted postmortem examination, that is PW कितने सी है 5 na PW5 has noticed only one stab wound and the other injury, that is the lacerated wound which was noticed on the mouth, has been clarified by the doctor to have been caused by tongue bite of the teeth of the deceased. Therefore, if the appellant had selected a time that is midnight to commit the offense and had only given one blow to the deceased, it was expected of him not only to conceal his identity but also to leave the spot as quick as possible so that nobody could mark him. And the evidence on record indicates that after the deceased was assaulted, he went to his wife, that is PW6, informed him, and then PW6 came to the then to the entry point, and then she shouted, and PW4 woke up and chased, saw the deceased, saw the appellant leaving the spot and chased him. So, if that would be the sequence of events, it is not believable at all that the appellant, the deceased, would have remained at the spot for such a length of time to be noticed by all these three witnesses. Therefore, the evidence of these three witnesses, that is PW4, PW6 and PW8, that they marked the appellant escaping from the spot house in the occurrence night, is done inspire confidence, more particularly when the said fact is conspicuously absent in the first information report, so also in the statements of these witnesses given during course of investigation. The next circumstance, that is the recovery of the weapon of offense, that is knife and one bulb, from the paddy stacked in the first room of the spot house where PW 4 was sleeping, is another doubtful feature, in as much as if it is not at all believable that after committing the crime, when the deceased was shouting, the appellant would remove the electric bulb and then keep it along with the weapon of offense in the very said room where PW4 was sleeping. Because in as much as there was every chance that on hearing the shout of the deceased, the family members, including PW4, are likely to wake off. Therefore, ordinarily, it was expected for the person to leave this place as quick as possible. And it seems that the investigating officer has created this part of the story in the prosecution case just to create one circumstance against the appellant. There is no dispute that in view of the evidence of the doctor, the deceased met with homicidal death. But since there is no direct evidence and the circumstantial evidence appearing on record are not established by clinching evidence, and they also do not inspire confidence of the court, we are not inclined to place any reliance on the same. And in our humble view, the impugned judgment and order of conviction not sustainable in the eye of law. Accordingly, the appellant is acquitted of the charges under section 450 and 302 of the Indian Penal Code. The appeal is allowed. He is in custody.
No, he's on bail.
Okay, it is stated that the appellant is on bail. So the bail bonds and so on so stands cancelled.
Online.
Only good just you just add it so that you can make it. With regard to the identity of the accused, having regard to the peculiarity of the circumstance where the appellant is closely related to the witnesses with PW3, PW4, 6, and 8. It would not have been toiled much to the witnesses to identify the culprit, if at all the statement of the witnesses are accepted to be true, as because they are so much acquainted with the gesture, posture of the culprit that even if his face was found concealed, it would not have been difficult for them to identify. Another aspect which cannot be blinked aside is the fact that and also the prudence demand that in the case where the culprit is so closely known to the witnesses, in the event of the incident having taken place in the adjacent place where the witnesses, the deceased was sleeping, nearby the place where the witnesses were also sleeping, could have escaped their notice on the hulla being raised by the or the utterance being made by the deceased, giving so much of time to the appellant to move around to conceal the weapon of offense. Likhit.
That's all.
बोलेंगे।
Pardon, my lord. Item number 344, my lord. Both are juvenile student. One of them student, my lord. Custody since, my lord. 30th can take on to in time permit.
344.
344, my lord. Criminal division of 531 2023.
Case diary was earlier called for.
Yes, my lord.
So social investigation report has come. Mr. Tripathi, I'll just note it and see if it has come.
78, my lord.
One by one.
278 for interim bail, my lord.
217.
78, my lord.
278 hours.
For interim bail.
Take lord.
ଆଉ ଗୋଟେ ମିଲର 260 ରେ ଯିବ ଷ୍ଟାଟସ୍ ରିପୋର୍ଟ ଖାଲି
278 କଣ ହେଲା
ଇଣ୍ଟରିମ୍ ବେଲ୍ ମିଲର ଥିଲା ରିପୋର୍ଟ ପାଇଁ
ଯାଇଥିଲା
ଯାଇଛି
କେତେ ନମ୍ବର ଆଇଏ କେତେ ନମ୍ବର
ଆଇ ମିଲର 3 ମାସିଆ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଡ୍ୟୁ ଟୁ ମିଲର
ଆଚ୍ଛା
ଆଉ ଗୋଟେ 260 ଷ୍ଟାଟସ୍ ରିପୋର୍ଟ
ଆଗେ ଗୋଟେ କୁହନ୍ତୁ ଏଇ ଯୋଉ ଆଇଟମ ଟା ମେନସନ କଲେ
278 ମିଲର ଟେକ୍ ଅପ୍ ପାଇଁ
278 କଣ ଏଟା ମାନେ
due to Miller long detention, my lord, last occasion call for the status report and status report already Miller.
This accused name is Mir Roshan Ali. He was released on bail on 18/11/2022 for a period of 3 months.
Yes, sir.
With a direction to surrender on 16/2/2023.
Yes, sir. Then 70 surrender.
You did not surrender. Surrender on 17/2.
September month.
So, what is since when you are in custody?
I guess.
How many? 8/11/2020 रे custody अपन गले. से commercial quantity of ganja. So, what is the stage of the trial now?
Report is there, Miller.
Official witnesses have already been examined. So,
what interim bail
what is the stage of the trial unless I know it? How can
last Miller that report is also indicate Miller.
indicate
in stage of trial Miller only 3 more witnesses Miller is there to examine.
Court लिखा है जी.
आगे order रे Miller आस्थिला.
Till date, all the prosecution witnesses 15 as per sworn so furnished by the have been examined except the IO.
Yes, IO.
Last witness examined on sworn so further during petition.
Only 1 month interim bail and
call petition.
Other also suffering from cancer.
No, that is a report of dated 23/6/2020.
My lord, consider that gote masa रखिथिले जेतु गोटे दिन डेरी रे सरेंडर करथला बोले सेप्टेम्बर उ consider.
एबेगा स्टेटस न जाना पड़ले.
For 1 month Miller time.
The Learned Council from the report dated 1/8/2023 of the Learned Additional Session Judge comes Special Judge Nimapada. It is not found out that whether what is about the stage of the trial. Let the Learned Trial Court give a press report relating to the status of the case. बाकी usual order कर देबे next week आसियो. Yes.
260 status report call करब 260 रे कस्टडी मिलर 14/2022
এটা वाला के नंबर आइटम
लाइट 3
278 out of कोटा कहउचंदी
260 मिलर कस्टडी 14/5/2022 out of 24 witnesses no witnesses examined
custody के भेला
14/2022 मिलर.
all right. BLFPL number 4881 of 2022. The Learning Council for the petitioner submitted that even though the petitioner is in judicial custody since 14/5/2022, but not a single witness has been examined.
out of 24
charge frame है नहीं?
charge frame भी है रहे out of 24 charge already framed out of 24
even though charge has been framed, let a status report be called for usual order for the
I may be pardoned, my lord. 340
343 my lord.
342 millar is juvenile bail.
343 also, my lord.
342.
42.
My lord, 343 also.
More than 1 year in custody, co-active released on bail.
342 এটা first time আসছি না আগুর আসছিল না any that case diary has been called for, or if it is a fresh matter then 384 টা বার করলেন যে 342 টা
42.
just a minute, whether any order has been passed or no. 28 yes. So you see whether that has come or not. Item number 340.
343, my lord.
One by one. Yes.
343, my lord. He's a juvenile, my lord, and in custody since 2/8/2023. And my lord, last occasion your lordship has called for the case diary and social investigation report, my lord.
No order.
My lord,
6 some time case diary social investigation. All right. So also this 344.
343, my lord.
343 as
My lord.
256 verification documents lordship.
339
yes.
256. And in jail custody.
Yes, just a minute. 256 कौन कहले?
Document verification of खाली bail bond. Document
you are a man from Murshidabad district. So okay. सेटाକୁ मार्क करी देखि दियंतु जे डॉक्यूमेंट आपनु देइथिले डॉक्यूमेंट तो देइ नथिले ए जो एड्रेस वेरिफिकेशन पैंतिला. So address verification plus about the authenticity of the local sureties. आछि कि नै रिपोर्ट देखि दियंतु मगे. हां नै आगुर देइथिले एडा 6-10 रे आस्थिला देइथिले. Yes.
मैडम 303 my lord 341 303 my lord bail जो matter my lord petitioner bail my lord
wait 303 टा कौन बार करो
303
कौन है जेटा
303 my lord bail जो matter my lord petitioner religion bail my lord the advocate for petitioner filed a time petition that was rejected after on 22 August my lord he was arrested and in custody my lord 303
okay. At the stage of appearance you did not appear for
yes.
which NBW was issued.
Yes my lord. And advocate for petitioner filed a time petition.
Then you are arrested by virtue of that. Yes, Mr. Das, eta likhi diyantu item number 303 was on bail hala due to non-appearance on the date fixed and non-taking of steps. Non-bailable warrant of arrest was issued, by virtue of which he was taken into judicial custody and produced before the London trial court on 22/7/2023, and since then he is in judicial custody. Belgium format रे करी allow कर दे.
Madam, I pardon item 341 my lord juvenile revision my lord
341.
my lord criminal revision 366 of 23 my lord.
You have not received you have not given the copy to the London State Council, or you have given. The noting is that 5D is not removed. 5D is that defect
The 5D removed and the
अच्छा
status.
all right এই টাইম মধ্যে কেস ডায়েরি আর সোশিয়াল ইনভেস্টিগেশন রিপোর্ট
called for
পাইছিল
is the last date.
দেখি দিଅନ୍ତୁ ଆଣିକି
My lord,
I may be pardoned, my lord.
I may pardon another matter, 294, my lord. The petition is custody since 10/5/2020. Last time status report was called for. Co-accused persons have been granted interim bail for a period of 3 months.
we'll see that yes next
Item 322, my lord.
Juvenile
bail 339.
339
Earlier, social investigation report was called for, that is available.
all right ଏଇଟାକୁ ମଗେଇ ଦିଅନ୍ତୁ ଦେଖିଆ ହଁ ତାପରେ
My lord,
322, my lord.
294 ta status report at flag A, my lord.
hmm.
More than 3 years in custody.
we'll see that in the
Well,
matter
Item 322, my lord.
yes Mr. Pujari
164. In custody since 9 years.
just a minute. One 164 कौन कହୁଛନ୍ତି
It is of 2022.
yes
All bail applications up to 2023 have been allowed.
hmm.
It was in the list. It was went out of list last week. I mentioned, so it has come today.
No, it's all right.
Can it be taken up?
The case diary is available. Verify, and if any
I'm giving all the
if the bail orders have been passed in respect of the co-accused person,
my lord,
so hand over the
My lord.
copies so that he will verify about the claim of parity.
my lord.
Number.
Item 322, my lord. Wrongly listed before your lordship, my lord. Item 322. Sir, anticipatory bail.
Just a minute.
Counter case टाକୁ देखिକି से earlier disposal.
Wait. 322 though.
My lord.
322 doctor.
Wrongly listed, my lord.
Just a minute.
My lord, item number.
Wait.
Counter case is in annexure 2, my lord. In that case, two accused already granted.
The co-accused persons I have dealt with.
No, my lord. My case is 1cc case. The another counter case is the FIR case, my lord. तो FIR case टाକୁ देखिए सेटा लिस्ट कर दीजिए.
Wait. ଆପଣ ପରା ନିଜେ ଲେଖିଛନ୍ତି ଯେ 1cc କେସ୍ ଟା କଣ ଯାଇନି ଏପର୍ଯ୍ୟନ୍ତ ଏଠିକି ପୋଲିସ ଷ୍ଟେସନ କୁ ଯାଇ ରେଜିଷ୍ଟର୍ଡ ହେଇନି
ନାଇଁ
ହଁ
no my lord.
then what is this FIR?
There is annexure 2, that is counter case.
Dungurpally PS case number 80 of
80.
2021.
Yes, my lord.
The learned counsel for the petitioner submitted that it's a fresh bail application and the counter case, the bail application of the accused persons in the counter case, which corresponds to Dunguripalli PS case number 80 of 2021, has been earlier dealt with by me as well as by Honorable Justice D. Das. But the present case arises out of a complaint petition, that is 1cc case number 3 of 2023, and it has not yet been sent to the concerned police station under section 156(3) of CRPC for registration of the FIR. In view of such submission, the matter to be listed before the assigned bench.
And item 167, my lord. 167, my lord.
Kete number?
67 minor. Similar to 164 minor.
Konta? 164 रे मु कोन कहली कि अच्छा एटा ता संगे निया जीवो कोन ठीक है
167.
Item number 56. My lord, item number 91.
से जो 164
Seven,
संगे रे वो 267 टा निया जीवो 271 just a minute. अच्छा प्लस 271 एगुड़ा टिके देखी दियंतु को अक्यूज जो बेल जाइछंती हां नहीं 164 267 271 they all arises out of one PS हां अपन खाली वेरीफाई करिया पड़िबो से को अक्यूज सेम फुटिंग की नाही हला से अपन को देलेनी बेल ऑर्डर गुडा को केस डायरी देखिंगे तीनटा अक्यूज्ड रो देखिबो
Item number
My lord, 91 my lord. 91. 91. 91.
wait
Item 69 my lord.
91 कौन
My lord. Here, my lord, occurrence of 2010. A petitioner arrested, my lord, 2016. 27/9/2016, my lord.
91 तो that is
Only 91, my lord.
हाँ मो BLPL 11099 of 2023
My lord, my lord.
सत्यनारायण
My lord,
भालवा।
my lord, my lord.
कौन हला कौन
My lord. Petitioner is in custody, my lord, 27/9/2016.
ये
There are, my lord, 33 charge sheeted witness.
ये
Out of them, my lord, 13 witness has been examined. It is a old case.
33 ରୁ କେତେ ହେଇଛନ୍ତି
My lord,
33 ଟା ୱିଟନେସ୍ ରୁ କେତେଟା ହେଇଛି
13 ଜଣ।
କେବେଠୁ କଷ୍ଟଡି ରହିଲାଣି
27/9/2016.
Okay, status report तो आसी नथला लेखिजन the London Council for the this is item number 91 the London Council for the petitioner submitted that the petitioner is in judicial custody since 27/9/2016 you are never released on interim bail
No, my lord.
and he has never been released on interim bail and in the trial court out of 33 charge sheet witnesses only 13 witnesses have been examined hala status report magidin yes
77, my lord.
Before auditor directed for my lord medical report my lord for it is interim bail my lord my main
just a minute just
mother is seriously
wait हाँ 201 ने तो किसी interim bail application नहीं okay on what ground you are seeking
mother my lord that's why you not seek bail for the report on 18 2020
just a minute I'm petition seeking for interim bail on the ground of ailment of the stated to be suffering from kidney problem अच्छा आधे आश्ची की नहीं रिपोर्ट टा टिके फाइल मगे देखी जाए
Item 69 my lord. Item 69 my lord. Here my lord, petitioner is in custody from 10/5/2020 my lord.
just a minute
More than 3 months in
69 कौन वाला कौन
petitioner is in custody from 10/5/2020 my lord. My status report
10/5/2020
2020 my lord.
हाँ कौन पोजीशन कौन से थी
Only my lord last September my 2022 till that only 5 witnesses was examined.
टोटल एक केस रे 5टा साखी हिचन
Yes my lord.
केतेटा समुदाय साखी
17 my lord out.
ऑलराइट स्टेटस रिपोर्ट मगाई नथिला गुरु
नहीं मौका है
हाँ
मौका है
हाँ लिखंतु that is DLAPL number 10456 of 2023 the London Council for the petitioner submitted that the petitioner is in judicial custody since 10/5/2020 and in the meantime trial has commenced and out of 17 charge sheet witnesses 5 witnesses have been examined in view of such submission status report कर दूँ our London Council for the state shall produce the case diary and also obtain instruction about the criminal antecedent if any against the petitioner yes next
another my lord
56, my lord. Item number 56, my lord, petitioner is in custody from the year of 2019.
56
my lord.
ହଁ ଏଇଟା ଫ୍ରେଶ ମ୍ୟାଟରଟା ନା ଆଗରୁ ଆସିଥିଲା? ହଁ ଆଗରୁ କେବେ ଆସିଥିଲା? କାହିଁ ତ ଦେଖା ଯାଉନି କିଛି ଆଗରୁ ଆସିଥିଲା ଭଳିଆ ନା ଆଗରୁ ଆସିନି ଫାର୍ଷ୍ଟ ଟାଇମ୍ so what is your submission in this case?
Earlier petition before your lordship by DLPL number 1151 and he is in custody from 2019 and some of the material witness has been examined and turned hostile also, my lord.
2019 he is in custody.
My lord, my lord.
So how many witnesses have been examined?
My lord, six witnesses.
Out of 24. So it's a case under section
302 and 34, my lord.
So have you supplied the deposition copies of those witnesses?
My lord, I have copy and
Give the learned
my lord.
the learned counsel for the petitioner. Are you supplying just now or
My lord, just now.
submitted that the petitioner is in judicial custody since 2019 and out of 24 charge sheet witnesses, 6 witnesses have been examined. Let the learned counsel for the petitioner supply the deposition copies of those witnesses to the learned counsel for the state. Will obtain the case diary and verify whether any other material witnesses are yet to be examined or not.
My lord, item 69 is 17 ଜାଗାରେ 12 witnesses, my lord.
କୋଉଟା?
ଏଇ 69 ରେ ଯୋଉ 17 କହିଲା 12 witness out of 12 witnesses ପାଇ
ଆଚ୍ଛା ତା ପୂର୍ବଟାରେ 17 ଜାଗାରେ 12 କରିଦିଅନ୍ତୁ ବୁଝିଲେ ନା 12ଟାରୁ 5ଟା ହେଇଛନ୍ତି ହେଲା।
and another item, my lord, 210, my lord. Item 210, item 210, my lord. 210, my lord.
My lord.
Yes.
Item 219, my lord. As per the earlier, the person is behind the bar more than 6 years, and as per the last order, that is on 19/10/2023, my lord, there is the report call for to list this matter on 6/11 regarding the status and
It was earlier rejected.
my lord.
So since when you are in custody?
My lord, I am in custody since 5 March 2017.
Earlier it was rejected or you are granted bail?
Interim bail.
Interim bail. When?
My lord, last interim bail.
What is the number of that?
My lord, DLAPL number 995 of 2022. And another one also interim bail.
The report indicates that you are released on interim bail on 3 occasions.
My lord.
And you surrendered in the court after expiration of the interim bail period at right time in 2 occasions. And in 1 occasion, you surrendered 5 days after the expiry of the interim bail order. Okay.
My lord, out of 87 charge sheeted witness, only 30.
87 नु 44 टा witness ହେଇଛନ୍ତି ଯାହା report ଆସୁଛି. This is report dated 31/10/2023. Last time you are released on bail in BLAPL number 995 of 2022 for a period of 3 months. All right, heard the learned counsel for the petitioner, learned counsel for the state. Period the status report submitted by the learned trial court dated 31/10/2023, from which it appears that out of 87 charge sheet witnesses, 44 witnesses have been examined so far, including the informant, and the petitioner has been released on interim bail thrice by this court. And on 2 occasions he surrendered at right time, but on 1 occasion surrendered after 5 days after the expiry of the interim bail period. The petitioner was initially taken into judicial custody on
5th March 2017.
6th March,
5th
March 2017. Considering the submission made by the learned counsel for the respective parties, the inordinate delay in disposal of the case and the period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on interim bail for a period of 3 months. It will appear before the learned trial court on each date.
Item 210, my lord. Item 210, my lord. The main accused has been released on bail. Item 210, my lord.
Yeah.
210, the main accused has been released on bail. I have served the extra copy. I am the person who helped my lord to arrange a room of my relative.
So give him and he will.
I have also gave extra copy, my lord. My lord, 210, my lord.
କହିଲି ସେ ରେକର୍ଡ ଆଣନ୍ତୁ ତାହେଲେ 200 କେତେ
77.
what you want is that IA you want to withdraw because it's a disposed of bail application. All right, IA number 13, that is 277. IA number 2514 of 2023 re IA number 1355 of 2023. This is an application for extension of interim bail. You are filing a memo. The Learned Counsel for the petitioner files a memo for withdrawal of the interim application. Accordingly, the IA is disposed of as withdrawn. Yes.
My lord, I to mention, my lord, today we will list item 184. See, IIFL bank loan case, not case. My lord, kindly see the order passed by my lord on 23/9/2023. Parity ସବୁ ଗଲେଣି.
ଯେତେବେଳେ ପଢିବ ଦେଖିବା. Yes, ପଢି.
order on 23.
We'll see when the matter reaches. We'll see. Yes.
198
My lord,
198 your lordship already. 198 your lordship already status report received your lordship. Petitioner is custodian 13/10/2020 your lordship. Other co-accused persons are released on bail your lordship.
198
My lord, my case can be taken up to the 7 to 8 times ଉଠିଲାଣି reach ହଉନି.
এটা হচ্ছে granted interim bail for a period of 3 months once after availing surrender at right time he has instructions of 3 witnesses. Report मगाइथला.
My lord, I pray that my matter item 184 may can be taken up.
ଅପେକ୍ଷା କରନ୍ତୁ 21 number of charge witnesses, 4 witnesses have been examined. All right. You are taken into custody when?
Your lordship 13/10/2020 your lordship.
At 10/10/2020.
Your lordship.
Earlier you were granted interim bail.
First 3 months.
By which order? In which BLAPL?
Your lordship 3293 of 2022. 3293 of 2022.
Where is that order?
Your lordship.
Where is that order?
Your lordship.
Bring that order, we'll see. Yes.
Lordship, item 268. The accused is in custody from 23rd/5/2015. More than 8 years, Lordship.
268.
268, Lordship. All directors have been released on bail.
Okay, we'll see when the matter reaches. Yes. Next.
Item note 321.
Yes.
Item note 321.
Yes.
I mean,
yes, sir. Make your submission. What do you want?
yeah, this is the allegation against the present.
No. Why are you making mention?
Seems
I'll go serially, not that. Yes, no.
4 times
Yes, sir. Call the matters from the supplement.
Pardon to mention, my lord. My lord, may I mention item number 312?
Call the matters from the supplemental list. Yes.
My lord.
Supplemental
list item number 1.
Yes.
May I please?
Pardon to my lord.
Mute kar diyo. Yes.
May I please, my lord?
My lord, there is an
Yes.
Your lordship has I had order dated 24/11/2022, my lord. Your lordship has allowed me to go on interim bail for 3 months, my lord, and the bail application was disposed of. Since I was in custody in respect of another case, so I could not be released on that. I could not enjoy the bail. But Annexure 1, my lord, your lordship has allowed that bail application also. In that case, after passing of this order, Annexure 1, so I released on bail, and
23/8/2023, my lord. While I was in custody, my lord, all the witnesses, material witnesses have been examined, my lord. And I have given the deposition copies also, my lord.
Why you have filed a interim application in a dispose of matter?
My lord, for extension of some time, my lord.
What extension?
Extension of, because all the witnesses have been examined.
File
except
renew the prayer first in the trial court and then come. It's a disposed of bail application.
Yes, my lord.
If
Yes,
you
my
say that witnesses have been examined,
Yes,
they have not stated anything.
No.
So make an prayer before the concerned court, trial court. If rejects, come to this court so that it can be taken up. IN number so and so. This is an application for appropriate order. It's a disposed of case. Therefore, I am not inclined to pass any order in this interim application, which is accordingly disposed of. Yes, next. The petitioner is at liberty to file a fresh bail application in accordance with law. Yes.
Item 2.
Yes, Mr. Das.
Yes, may I please? May I pray, my lord? Item number 2 and item number 5, the supplementary list, my lord.
Yeah.
And week list number item number 3, my lords. All are connected matter, my lord. All 4 cases, this court was pleased to release the present petition interim bail at the first instance by my lord, another bench, my lord, for 45 days. Subsequently, that interim bail was extended for another 30 days. Thereafter, petitioner moved the Honorable Apex Court, and Apex Court also extended that interim bail for the 6 weeks and further requested this Honorable Court to dispose of the bail application within that period, my lords. And so far, the 4 cases concerned, my lord, I am filing that comprehensive affidavit, my lords. And almost all the cases, my lords, the appellant inside custody more than 2 years. And trial has not, there is a extremely slow progress of trial, my lord.
How many witnesses have been examined in each of the cases?
Each mission. So for the present case, which is in my lord's hand, my lord, that is a case, my lord. The charge has been framed on 9/2/2023, and there are altogether 142 are the charge sheeted witnesses.
All right, let me call for a report. BLAPL number 6511 of 2022. The Learned Counsel for the petitioner submitted that even though the petitioner is in judicial custody for more than 2 years, but there is slow progress of the trial and co-accused persons have been released on bail. In view of such submission, let a status report be called for from the Learned Trial Court. And while submitting the report, the Learned Trial Court shall specifically indicate that when the petitioner was taken into custody in connection with this case, the date of framing of charge, the total number of witnesses as per charge sheet, whether the prosecution intends to examine all the witnesses or filed any memo to decline any witnesses, and how many witnesses have been examined so far, whether the petitioner has availed the interim bail order at any point of time, and if so, whether he surrendered at right time or not. The Learned Counsel for the state, you have obtained the case diary?
Yes,
and also the criminal antecedent.
Yes.
The Learned Counsel for the state submits that he has received the case diary as well as criminal antecedent. List this matter next week, next Friday.
In this case, I am appealing for the informant.
The Learned Counsel for the informant is present. A type order for the item number 2, then
Number 5, supplementary.
Just a minute. Item number 5, then
my week list item number 3, there are 2 items.
just get the number weekly no?
3 item
3.
3.
Yes, how?
না সে
3টা
আগে
আচ্ছা সেটা করদেবে এটা তা উইথ ହେଇକିନା ଆସିବ ଏଇଟା ଖାତାଟା କାଇଁ ମୋ ସାମ୍ନାରେ ଦେଇଛ ପରେ ତୁ
ମୋର That is a common cause of action, my lord. I am, though I am not specifically, I am in this case, I am the informant in item 2. For all connected matters, my lord, arrangement of time.
File your appearance memo. Otherwise, I will hear only you in this item number 2. Okay. Yes. Next.
Yes.
Published.
No, item number 3 there are 2 items.
Item number
3 re 3 weekly re dita matter.
हाँ weekly item 3 ने dita matter है. Yes.
Your Lordship, I'm sorry to bring it to your Lord's notice out of context.
Yes,
Similarly,
item number 3.
Your lordship.
Yes.
The earlier occasion, your lordship directed for instruction for the medical reports submitted by the petitioners. The petitioner mother is aligned, and the conducting doctor suggested for open heart surgery, that is CABG.
You have filed an interim application
Interim application.
for bail on the ground of mother's ailment. So, what report has been received?
From the other instruction that the present petitioner is now staying with his younger brother, namely Vishwajit Sahu. That is one issue. Apart from that, the medical reports given in this case, do not suggest any type of surgery. Lordship find from the report.
ଯାହା କହିବା କଥା ଲିଖିତ ଆକାରରେ ଦିଅନ୍ତୁ ହେଲା ଯେ ଘରେ ଅନ୍ୟମାନେ ପରିବାରରେ ଅଛନ୍ତି ଯୋଉମାନେ ତାର କେୟାର ନେଇପାରିବେ ଏଇ ଯୋଉ ଡିଜିଜ ଅଛି ଆଜିରେ ଅପରେସନ ଦରକାର ନାହିଁ ଡକୁମେଣ୍ଟ ଗୁଡାକ ଜେନୁଇନ ନା ନାହିଁ ସେ କହୁଛନ୍ତି ତାଙ୍କ ମାଙ୍କର ଅପରେସନ ପାଇଁ ଦରକାର ତ ଆପଣ ଯଦି ଡକ୍ଟରଙ୍କୁ ଦେଖେଇବେ ଯେ ନାଇଁ ଡକ୍ଟର ଦରକାର ନାହିଁ ଯାହା ବି କହିବେ ମୌଖିକରେ କିଛି କୁହନ୍ତୁନି କେମିତି ଆଣିବେ ମୁଁ ଜାଣିନି କମିଂ ୱିକ୍ ରେ ଆପଣ ଆଣିକି ଇଏ କରିବେ ହେଲା yes
My lord, I am submitting one papers only. The petitioners already, the brother of the petitioner already appointed Dr. Hart in some ultimate. The operation will be conducted in the coming week. That is some ultimate report. Operation ta budhbar na shukrobar hobo.
Yes. Next, the Land and Council appearing for the state of Odisha in OPID Act matter. What is your good name? Anil Kumar Naik. Submit that the matter may be taken up next week in order to obtain written instruction on the interim application. IN number 582.
No, sir. IN number 1476.
Acha, 1476, sorry. 1476 of 2023. It's an application for interim bail. Okay. Yes, next.
Obliged.
Item 4.
Item 4, my lord. On behalf of Mr. Deepak Sahu, I may be permitted to place the matter. The lordship may kindly see order dated 3/11/2023, my lords. Your lordship directed the State Council to obtain the criminal antecedent and report of the my lord.
Hela.
Yes, I am. No, yesterday he had communicated the letter.
So you want some further time? Yes. The Land and Council for the state has produced the report of the so and so, which indicates that communication has already been made to the concerned authority for obtaining the instruction about the address verification, and he seeks some further time to produce the report, put up this matter, give it the date. Yes, next.
Item 6.
Here may I please your lordship, petitioner is a lady, custody 19/10/2021. In last order, my lord, call for the status report before the Lord and my lord, additional session judge Baleshwar firm regarding my lord stage of trial.
Report asila na. So charge was framed on 5/1/23, and out of in between 13 witnesses have been examined out of 19. Only 2 witnesses are yet to be examined. The last witness was examined on so and so. What do you want?
Interim bail
Why?
19/10/2021 lady petition is lady my lord 19/10/2021.
ଆଗରୁ ଯାଇନଥିଲେ?
ନା ମୋଟେ ଯାଇ
Yes, कौन कहउछन Mr. Tripathi? The learned counsel for the petitioner, learned counsel for the state. The learned ये जो आगुर जो बेल एप्लिकेशन उड़ा कौन सब रिजेक्ट है जी नंबर जो देइछंती
रिजेक्ट मिलर यार को आके ओटे नो
रुक्षाना
एके
बीबी
दियो
विथड्रॉ करछंती ता पूर्वटा रुक्षाना बीबी
10,882 22/2/2023 ଗୋଟେ ମିଲର ବିଏଲଏପିଏଲ 11,310 ଅଫ୍ 2021 ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଛି 9/1/2023 ରେ
ओके जणे कोआक्यूज को बेल दिया इतला
ପଜେସନ ରେ ନାହିଁ
जोत्स्ना मुर्मू
डिफरेंट
learned counsel for the petitioner submitted that the petitioner is a lady and she is in judicial custody since 19/10/2021 and in the trial court out of 19 charge sheet witnesses 13 witnesses have been examined and she is a local person and therefore the bail application she may be granted interim bail for some time. Learned counsel for the state opposed the prayer for bail on the ground that commercial quantity of brown sugar was seized from the possession of the petitioner and into the bar under section 37 of the NDPS Act. She is not entitled to be released on bail. Sapara, review the status report submitted by the Learned trial court which indicates that out of 19 charge sheet witnesses, 13 witnesses have been examined and only 2 more witnesses are to be examined. And effective steps have been taken for disposal of the case within first quarter of 2014. Considering the submission made by the Learned Counsel for the respective parties, in view of the materials available on record, the seizure of commercial quantity of brown sugar from the possession of the petitioner and bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail on merit but taking into account the period of detention of the petitioner in judicial custody, the progress of the trial so far, and that the petitioner is a lady, I'm inclined to release him on interim bail for a period of 3 months. Disposed of. Yes,
Item 7.
so he has not surrendered. Disposed of case. Let peruse the letter of the Learned Additional Session Judge CORAM put at flag K. Since the Learned Trial Court has already taken steps in accordance with law for the apprehension and production of the petitioner who flouted the terms and conditions of the interim bail order, no further order is required to pass in this disposed of bail application. Yes, next.
Item 8.
May I please, Your Lordship? Your Lordship had called for a report. A/1.
What report I called for?
Your Lordship, query was
Regarding other accused persons.
how many accused persons have been released on bail in this case and about their names and whether any of them have been directed to furnish case security or not.
What is the report?
Flag A.
In obedience to the direction of the so and so, passed in so and so, that 6 accused persons, so and so, have been released on bail, out of which Antarjami Senapati was directed to furnish cash security only, and he has furnished the same and released on bail. So that is the report. This is a OPID Act matter.
No, this is the matter, EOW matter.
हाँ अच्छा अपन करिवे तो. So what is the date of custody?
11/4 your lordship.
11/4 कौन?
এই বর্ষ this year my lord.
2023.
Yes, Lord.
Charge sheet submitted under section
Charge sheet under my lord 419, 420, 67, 468, 120B.
Okay.
406 and 471.
406.
So far as this petitioner is concerned,
Allegation is he impersonated one Satyabhama.
কোডি লেখা আছে সেটা?
এইটা স্যার ইয়েরে নাই এই যে
চার্জ শিটে লেখা হয়নি?
চার্জ শিট রে আছে।
ও কোড দেখুন আগে।
Page 46 my lord. Page 46 of my brief.
46. हाँ पढ़ो तो कोड लिखा है।
18.15 last paragraph your lordship. Investigation further discloses that Satyabhama Das is a housewife and has purchased a land such and such Molipoda 150 decimil from one Hirendra Kumar Samantra and others on 19/4/89. It was further ascertained that the said land is bounded by a concrete wall since long. It was ascertained that while Satyabhama's son, namely Manoj Kumar Das, went to deposit rent land of the said land, he could find that some patches of land have been illegally recorded in the name of Pradeep Behra, Monalisa Behra, Sulochana Pradhan, Damayanti Das without their knowledge. It is revealed that an unknown impersonated her mother as Satyabhama Das using forged Aadhaar card away from the patches and such and such. Then I am taking your lordship to 1818 to the bottom paragraph.
1816.
अच्छा.
Investigation reveals that accused Gayatri Malik, myself your lordship, has impersonated her as Satyabhama Das in pursuance of a criminal conspiracy with the identifier Krishna Chandra Behera and others have illegally sold away the 4 patches of land of Satyabhama Das in Mauja number such and such and photograph in most. It is further revealed that Gayatri Malik used forged Aadhaar card and photograph in a most fraudulent manner to forge the actual Aadhaar card of the bona fide owner of the land, namely Satyabhama Das, and also has physically remained present during execution of the forced sale deed in the office of the sub-register. Then at paragraph 1818, my lord, about the financial transactions. It is revealed that identifier Krishna Chandra Behera, knowing fully well that Gayatri Malik has impersonated Satyabhama Das, identifier has identified her as Satyabhama Das. Krishna Chandra Behera had identified the impersonated lady as Gayatri Malik and facilitated the execution of the fraudulent sale deed in favor of Pradipta Behera, Monalisa Behera, Sulochana Pradhan and Damayanti Das. It is further revealed that Krishna Chandra Behera along with Gayatri Malik has taken 10,000 from accused person namely Antarjami Senapati and Horodhara Das to remain present at the SR office at the time of execution of the sale deed. It is further revealed that Krishna Chandra Behera has also given thumb impression and his photograph in the said for sale deed besides using his Aadhaar card and voter ID at the time of execution. It is ascertained that the accused persons namely Antarjami Senapati, Ananta Pradhana and Horodhara Das and others have received 2 lakhs from Pradipta Behera, 9,20,000 Sulochana Pradhan and 2 lakhs cash from Monalisa Behera. It is ascertained that these persons have failed to give possession of the said property after sale and also failed to return their sale consideration money. Hence, the accused persons have committed such and such.
What is your submission?
My basic pursuant to your lordship query, they have produced a document, your lordship, on last occasion which shows that I have received 4 lakhs in case. Now, question is, my lord, when the FIR was lost, this one Mamata was also named there, who has also been granted bail by your lordship in the first case that was disposed of, your lordship. I am already in custody since 11/4. All the accused persons have been released on bail, including this identifier, my lord.
Yes, Mr. Tripathi, what do you say?
Where last report which I have submitted, my lord, you kindly glance on 10/11. Total transaction was 18 lakhs. Nowhere it has taken 4 lakhs.
No. Why I have said 4 lakhs? It is there account of the son of Horodhar Das, accused person. Hododara Das son has received 9 lakhs in his account, who is an accused and already released on bail.
But so far, Gayatri, there
And
is no specific we have mentioned. We have mentioned the impersonate in this 4 line, your lord.
No, in the charge sheet it is mentioned 10,000.
10,000.
10,000.
Are the Mr. Sarangi and senior advocate appearing for the petitioner submits that the petitioner is in judicial custody since 11/4/2023 and she has been charge sheeted under section 406, 419, 420, 467, 468, 471, 120B of the Indian Penal Code. The offences are triable by magistrate. And he placed the 18.15, 18.16 and 18.18 of the charge sheet, which reads as follows. Quote those things. The Land Council submit that the co-accused persons have been released on bail and therefore the case of the petitioner may be favorably considered, particularly keeping in view the proviso to section 437(1) CRPC. Land Council for the state opposed the prayer for bail and submitted that the petitioner impersonated one Satyabhama Das, and whereafter the land transactions were made, and
she was identified in the TI period.
And she was also identified in the TI period. Considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, the release of the co-accused persons on bail, and keeping in view the nature of accusation and provided to section 437(1) CRPC, I'm inclined to release the petitioner on bail subject to furnishing cash surety of rupees 10,000. Yes.
Item 9.
Your Lordship earlier disposed of the bail application of the petitioner under Annex 3 at page 10. On 21/3/23, your Lordship was kind enough to grant liberty to renew his prayer after examination of the eyewitnesses.
Which is that bail application?
Bail application 9556 of 2023.
Have you annexed it?
Yes, I have. No, present is, yes, I have annexed. That is 8269 of 2022 at page 7. At page 7 of my brief, your Lordship specifically directed while disposing the bail application, out of 5 accused persons, 4 have been released on bail.
Just a minute. Eyewitnesses account of number of person post-mortem report finding I am not inclined to release the petitioner on bail. Case has been committed to the Court of Session. So PP to furnish a list of witnesses, then summons to be issued, eyewitnesses to be examined at the first instance, then you are given liberty to renew the prayer for bail.
Yes, page 18, your Lordship, the informant is the wife of the deceased, and he claims to be the eyewitness to on the basis of that prosecution case was investigated.
No, eporjanto
out of 19 witnesses, 16 witnesses have been examined.
Have you
on
supplied
the date of filing of the bail
have you supplied the deposition?
Yes, I have annexed in this bail application.
Koodi annex korchen?
Either annexer 3 series.
No, ଆପଣ ଜମା 4ଟା witness ଦିଆଯାଇଛି।
4ଟା eyewitness କରିଦେଇଛି। ଅନ୍ୟମାନେ ସବୁ
ଆପଣ 1, 2, 3, 4 ଆପଣ ଦେଇଛନ୍ତି। ଆପଣ ନିଜେ କହୁଛନ୍ତି ଟୋଟାଲ ସଂଖ୍ୟା ହଉଛି 19, ତା ଦେହରୁ 16 ହେଇଛନ୍ତି। ତ ବାକି ଆଉ 12ଟାର ସାକ୍ଷୀ ଦିଅନ୍ତୁ ତାଙ୍କୁ, deposition କପି କୋର୍ଟ ପାଇଁ ବି ଦିଅନ୍ତୁ। The Land Council for the
I have prayed for interim bail because of mother illness. A report was called for by your Lordship previous day.
Out of 19 charge sheet witnesses, 16 witnesses have already been examined in the trial court. However, the Land Council for the petitioner has furnished the copies of deposition of only 4 witnesses, that is PWs 1, TO2 4. Let the Learned Counsel supply the deposition copies of the rest of the witnesses to the Learned Counsel for the state, as well as file a set of deposition for the court. Yes.
Interim application is pending. Well, you will also call for a report. Was kind enough to call for a report with mother illness. You will also
Aguru call for hinatila na.
Aguru heichi.
I have obtained that instruction.
What is the report?
Report.
Given.
Is in custody since 11/8/2020.
Okay, we'll consider it when if you do not get bail on merit.
Yes.
The next we'll consider it.
Next
the Learned Counsel for the state has produced the written instruction received from IIC Nandipada Police Station. It's dated 11/10/2023, relating to the ailment of the mother of the petitioner, which ground has been taken for interim bail in IA number 1241 of 2023. The report is taken on record. List this matter, give the date so that he will file.
Next.
You will file. Have you got the?
Yes, madam. It is there on the date of filing. These 4 were available with me.
No,
In the
no.
meantime,
ବର୍ତ୍ତମାନ ଆପଣ ଯୋଉ ବାକି ଆପଣଙ୍କର ଆଉ 12ଟା ୱିଟନେସ୍ କର
by next week
certified copy ଅଛି ତ?
ଆଜ୍ଞା.
Okay, furnish to the Learned Counsel for the state by next week. You give a date for listing. Yes.
Lordship fix upon that.
Yes, it will be
Friday.
Friday. It will be. You are to supply it by next week.
By Tuesday, I will supply. I undertake. Tuesday or
you have not yet obtained those certified copy. You are to.
My client's milord. He is also inside the court.
All right, next week or then. Yes.
Obliged.
Item 10.
May please. The modification of order dated manner 15/9/2023. It is wrongly mentioned the year of the case is 2023 instead of 2022. Mind. But the order.
All right, IA number 96 of 2023. This is an application for modification of the order dated 15/9/2023. It is submitted by the Learned Counsel for the petitioner that the bail application which was filed by the petitioner was BLAPL number 5008 of 2022, but in the which was dismissed for for default. But while in the operative portion, while mentioning for its restoration, the number has been inadvertently mentioned as BLAPL number 5008 of 2023. In view of such submission, it is made clear that BLAPL number 5008 of 2022 is restored to its original file, and the order dated 15/9/23 is modified accordingly. Yes, next.
Obligations.
Item 9. Instead of 16, 13 witness exam. 16ଟା କହିଥିଲେ 13 ଜଣ ଆଇଛନ୍ତି ଜୁଡିସିଆଲ ଅର୍ଡର
19 to 13 witness ହେଇଛନ୍ତି
13 4 ଦେଇଛି ଆଉ ନା
yes
Weekly list, item number 1.
देखो की नाहंती को
Lord, here rejection order is of 17/3/22, and at that time the court has reflected in his order that most of the CS witnesses have already been examined.
All right, non appeals for the petitioner. The rejection order is dated 17/3/2022. The Land and Trial Court, while rejecting the bail application, has observed that court election the
First,
that most of the charge sheet witnesses have already been examined. If the case is still sub judice in the trial court, the petitioner is at liberty to move the consent court for bail. Accordingly, bail application is disposed of.
Item 2. Item 4.
Yes, Mr. Das, Mr. Tripathi.
Yes, Mullah.
Eta kon hoichi?
29 charge sheeted witness, 9 witnesses already examined.
None appeals for the petitioner. Period the status report. Period the rejection order, which is dated 4/5/2023. If the case is still sub judice in the court below, the petitioner is at liberty to remove the fare for bail in the court below. Accordingly, disposed of. Yes, next.
Item 5.
May please lodge my lord. The petition is in custody, my lord. 29/7/20, my lord. 29/7/2020 my lord.
29/7/2020
Offense under section 20B2C. The quantity of ganja is 53 kg my lord.
So how many times you have
No, it's
come
fresh
to this court? Aguru asinathile?
No my lord. But aguru dita there is a prior to co-accused two. One is the Parminder Kumar Roy, bail appeal number 2463, and another is 2652 of 2021 Ranjan Kumar. Ranjan Kumar is allowed by this honorable court my lord. And the Parminder Kumar Roy, the lordship directed to in order dated 10/8/2021. Then also trial may be expedited in 6 months my lord.
So what is the position now?
Trial not be commenced as per instruction my lord. Not started my lord.
And what is the date of custody? 29/7/2020. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 29/7/2020. And while disposing of the bail application of the co-accused, namely Parminder Kumar Roy alias Sunil Kumar Roy, in BLAPL number 2463 of 2021 as per order dated 10/8/2021, this court directed the London trial court to expedite the framing of charge and to conclude the trial within a period of 6 months from the date of framing of the charge. However, he has received instruction that trial has not commenced. Let a status report be called for, file be placed before so and so. Yes, next.
Item 6.
May proceed. In the present case, your lordship granted bail to the co-accused. The kind of a glance to the my lord the
You were on bail during trial?
no my lord the bail my lord.
No, it out Belgium case no to?
No my lord.
Okay.
Here the petitioners are the father-in-law and brother-in-law of the accused Pradeep Das.
You have received the case diary?
Yes, my lord. That's it submitted 302/201 of the IP.
Wait. First bail application?
Yes, my lord. Since your lordship granted bail to the co-accused, it has been listed before lordship.
So there are two petitioners.
Yes, my lord.
Ramo Behera and the other one is
Nobo alias Nobhagana Behera.
And they are in judicial custody
Since 27/6/2023.
27/3. 6/2020.
Yes, 23.
2023.
2023. Okay. Here, madam, the charge sheet submitted under section 302/34 of the IPC, madam. The name of the deceased is
there are 29 charge sheeted witness. Out of them,
that time we arrested later on, but the person kind of glance your lordship your lordship's order, madam, page 25 madam kind of glance for a moment. Your lordship specifically stated there are one eyewitness Amuli Das, wife of the deceased, was present at the spot.
Who order kujandi?
Page 25 madam kind of glance.
Pradeep alias Tukuda.
That the fourth para, the London Council was submitted there. The petitioner is in judicial custody since 22/6/2020, and he has been charge sheeted under section 302/34 of the IPC. It is further submitted that the occurrence to question took place on 25/1/2020, and the petitioner happens to be brother of the deceased Pramod Das and the widow of the deceased Amuli Das, who is eyewitness to the occurrence, has attributed specific overt act of assault against the co-accused person, namely Santosh Das, Shiva Behra, and Ramo Behra is the petition number 1, who were stated to have been armed with deadly weapons. According to the lordship granted bail to Pradeep Das. Said persons, my lord, the trial faced by the Pradeep Das, they were examined as PW 3, my lord.
page 32.
Who was examined?
That Amuli Das, who is the eyewitness to the occurrence. Page 32 is her statement. He completely resigned for his for her version, and thereafter, my lord kind of glanced to page 42. That said that overtake was attributed against 3 persons. That as per your lordship's order, that Shibo Behera, page 32 my lord. Page
32 টা তো দেখিলে এভিডেন্স
evidence. Then my lord, page 42 my lord kind of glance. Annexure 5. That Shibo Behera and the Santosh Kumar Das, they are granted bail by this honorable court coordinate bench of the
30
page 44.
44
44 is the relevant part. Paragraph 7. It is seen that in the meanwhile, 8 witnesses have been examined, and out of these 8 witnesses, none of the independent witnesses, that is PW1 and 2, have supported to the case of prosecution. As noted, PW3, the widow of the deceased most interested witness, has resigned from her earlier statement. And in the meantime, that said Pradeep Das has already been acquitted. By the London trial court. And we arrested later because the investigation was open. We arrested later on by the investigating officer on 27/6/2023.
So you are an absconder for more than 3 years.
No, not an absconder. That investigation was open. The first charge sheet was submitted. My lord, charge sheet I have annexed.
ଆପଣ ଚାର୍ଜ ସିଟ୍ ହେଇନଥିଲା?
Nine. Page 14 ରେ ମୁଁ charge sheet annex କରିଛି my lord, kind of glance. Page 14. Only the charge sheet was submitted against only Pradeep Das alias Tuku Das. That I have annexed. That the relevant part is page 15 my lord. And the investigation opened recently. We arrested on 27/6/2023. We are the father-in-law and brother-in-law of the accused Pradeep Das. The deceased is the brother of the accused Pradeep Das.
But I have the charge sheet of 2020, where your name is reflected.
Not your name is, but charge sheet not submitted in the charge sheet column. My lord, kind of glance only Pradeep Das.
पेज नंबर 15 कथा कहउछन मिस्टर त्रिपाठी।
Yes.
15 नंबर पेज रे एवं 23 नंबर पेज को मध्य पळे आसन। 23 नंबर पेज रे जोटी कंक्लूजन अराइव कराई छी।
Yes.
सेठी आसन। Under the above facts and circumstances, so and so charge sheet submitted against Pradeep alias Tukudas, son of so and so, keeping the investigation open. Did you find it?
Yes, yes.
So, but investigation was kept open and subsequently they are. What is the name of the deceased?
From Pramod Das. And
right, 8 BLAPL number 8276 of 2023. The London Council for the petitioner submitted that the petitioner number 1, Ramo Behera, is the father-in-law, and petitioner number 2, Navo alias Navoghan Behera, is the brother-in-law of the deceased Pramod Kumar Das.
No, my lord. Of the accused Pradeep Das. Pramod Das hochi Pradeep Das ro bhai.
Acha. Of who accused Pradeep? Who accused Pradeep Kumar Das? Hala, Pradeep Das. And they are in judicial custody since 27/6/2023 and have been charge sheeted under section 302/34 of the Indian Penal Code. The witness Amuli Das is one eyewitness to the occurrence, but when he was examined in the trial of the brother of the trial
brother of the deceased.
Brother of the deceased. comma, the said Amulidas was examined as PW3 and didn't support the prosecution case. And in the meantime, Pradeep Das has already been acquitted by the learned
I
trial.
am giving the judgment.
He has filed the judgment copy with a memo which is taken. Memo
Memo টা করনি same.
judgment copy which is taken on record. Learned counsel further submits that in view of the nature of evidence adduced during trial of the co-accused Pradeep Das and the period of detention of the petitioner in judicial custody, the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that the petitioner was an absconder. However, the learned counsel for the petitioners submitted that when the first charge sheet was submitted on 18/10/2020, that was only against Pradeep alias Tuku Das, and the investigation was kept open under section 173(8) of CRPC, and subsequently the petitioners were arraigned as accused. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, nature of evidence adduced during the trial of the co-accused persons, and period of retention of the petitioner in judicial custody, I am inclined to release the petitioners on bail. Petitioners and they shall appear before the learned trial court on each date when the case would be posted for trial. Violation of any terms and conditions shall entail cancellation of bail.
My lord, मैं से court in session over there.
Court in setter hoy.
Okay.
Item 7.
May
Yes, Mr. Panda.
my lord. Occurrence my lord 2015 my lord. Arrested my lord 23/9/2022. Not arrested from the spot my lord. Sir my lord, the coordinated bench has rejected the prayer of the bail my lord. As because your lordship has granted bail in 8875, for that reason this one the matter has been listed here my lord. There are two witnesses identified while the petitioner fled away from the vehicle. They have examined and declined this my lord. PW2 and 3 are the star witness my lord. I have annexed my lord, page 18 and page 19. In view of their 161 statement, the present petitioner arraigned as an accused.
No, you are the only person who has been named in the FIR.
FIR. Because of the statement made before the police by the
identified by the
Gramrokhi, and for that reason I am named in the FIR. But they have declined in court my lord.
Who have been declined?
The Gramrokhi and page 18
Wait.
my lord.
I so and so received information that Tata Sumo loaded with so and so proceeded to. There was earlier information, SP ku janala, then proceeded to so and so. 7:15 we found and Tata Sumo vehicle was coming from Kontamal side. On seeing the police party, the driver of the vehicle fled away from the spot. By leaving the vehicle, we chased the driver, could not able to
Escape from the spot. The local Gramrokhi Bhagirathi Loha and the witness identified the driver as Krishna Chandra Putel. For that reason, I am named.
The local GR Bhagirathi Luha and witness identified this one so.
My lord.
PW2 is the Bhagirathi Loha.
कौन ला मना कला PW2
page 18
All right, heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody on Kebe
23/9/2022.
23/9/2022 to?
My lord.
And he has been charge sheeted under section 21
20 my Gonja case.
20B2C.
My.
20B2C of the NDPSR.
By 25 NDPS.
Oblique 25 of the NDPSR. The learned counsel submitted that when a Tata Sumo vehicle was intercepted by the informant and other police officials on 22/2015, on the road of Kusunga Chak in the district of Baud, the driver of the vehicle fled away from the spot, leaving the vehicle, and the local Gram Rakhi Bhagirathi Luha identified the driver to be the petitioner. The learned counsel further submits that the custody that the said Bhagirathi Luha has been examined in the meantime as PW2, and he has not stated anything against the petitioner. The Land Council further submits that six witnesses examined in the trial court have also not stated anything against the petitioner. And in view of the available material on record, cannot be said that there are reasonable grounds to believe that the petitioner has committed the offense, and in absence of any criminal antecedent, it cannot be said that while on bail, the petitioner is likely to commit such offense, and therefore the bail application may be favorably considered. Land Counsel for the state fairly submits that in the FIR it is mentioned that Bhagirathi Luha has identified the driver of the vehicle, and though it is further mentioned that the witnesses also identified the driver of the vehicle, but it is not mentioned who are those witnesses. Considering the submission made by the learning counsel for the respective parties, nature of accusation at petitioner, since the petitioner was not apprehended at the spot, and his identification is based on the version of one local Gramaraki Bhagirathi Luha were being examined in the trial court as PW2, has not stated anything against the petitioner, particularly to have identified the petitioner escaping from the offending vehicle. Keeping in view the provision under section 37 of the NDPS Act, and in absence of any material relating to his criminal antecedents, I'm inclined to release the petitioner on bail. Shall appear before the trial court on his date, and the case would be posted for trial allowed.
Item 8.
May please your lordship, ma'am.
Yeah.
This bail application we listed before my lord is because my lord has dealt with the co-accused person and granted bail, my lord. The present person is custody since my lord 22/6/23.
20?
22/6/23, ma'am.
Charge sheet helani?
Yes, sir, not
This is the case of 2011.
Oh,
This is a Mao and
you
absconder for 11 years.
okay. You have obtained the case diary.
Yes, ma'am.
So, whether there are any material against the petitioner in this case, or merely because he is a Maowadi, according to you, you have taken him into custody.
I will thoroughly verify, my lord, because this record is of 2011.
No, you verify, there is
Yes,
no
yes.
problem. You verify whether there are any other material, and have you obtained instruction about his criminal antecedents?
No, my lord, that is not come.
So that instruction also you received?
Yes.
2 cases filed, my lord.
I would arrow.
Next touch.
Next.
Say petitioner.
Again.
Okay. So both the cases you verify,
Yes.
and in both the cases you have received the case diary. The next
Yes,
item.
yes, ma'am.
All right. Take down item number 8 and 9, same order of the Learning Council for the state submitted that he has received the case diary and wants to verify the nature of accusation against the petitioner, and is yet to obtain instruction about the criminal antecedent, if any, against the petitioner. List this matter, give a date. Same order in item number 9.
Item 10.
Item 10, Mr. Sorangi. Devasis Sorangi. You have received the case diary?
Lordship, we have not yet received it.
May I please?
Yeah.
After getting a present petition, my lord, present petition is there, my lord. So, file the fresh bail, sorry, file the fresh Vihinama on behalf of the accused person, my lord.
এই কেসরে ଆପଣ consent ନେଇକି ନା ଗୋଟେ fresh
No, my lord. Prisoner petition, then
prisoners petition ଆସିଥିଲା এই କେସରେ କାହିଁ କାହିଁ ନାହିଁ ତ କିଛି prisoners petition ଆପଣ ଓକାଲତନାମା ଫାଇଲ କରି ସାରିଛନ୍ତି basing on that prisoners petition,
yes, my lord,
which is yet to be received.
yes,
अच्छा ଆପଣଙ୍କ ଓକାଲତନାମା ସାମିଲ ହେଇନି ତ କେବେ ଫାଇଲ କଲେ ଓକାଲତନାମା? କିଛି ଲେଖିକି ରଖିନାହାନ୍ତି ଫାଇଲରେ କେବେ ଫାଇଲ କଲେ?
I have no receipt, so. But my lord, the arising of the same FR, but is.
ଆରେ ବାବା ଆପଣ ଏ ମ୍ୟାଟର ଆର୍ଗୁମେଣ୍ଟ କରିବେ ତ?
No, my lord, your lordship
Sir, this is a different case.
Yes,
Which
yes.
case?
Yes.
1217 ଧରିଛନ୍ତି ଆପଣ? ଏଇ କେସ୍ ନୁହେଁ?
This is item number 10, BLAPL number 8353 of 2023. Prashant Dwivedi is the petitioner and Devasis Sarangi is the learned counsel for the petitioner. ଆପଣ ମ୍ୟାଟର ଆପଣ ଦେଇଥିଲେ ପରମିଶନ ଆର୍ଗୁ କରିବାକୁ ନା କଣ? I don't know idea. କହୁଛନ୍ତି ଯେ କଣ ଓକାଲତନାମା ଫାଇଲ କରି ଆପଣ ଏଇ ମ୍ୟାଟରରେ ଓକାଲତନାମା ଫାଇଲ କରିଛନ୍ତି?
Yes, ma'am.
କେବେ ଫାଇଲ କରିଛନ୍ତି? ନା
Let the office verify. Let him appear.
Alright.
I have nothing to do with it.
the
ଆପଣ କେସ୍ ନମ୍ବରଟା କେତେ?
Bail
ଏଇଟା?
application number.
835
learned counsel ଆପଣ ନାଁ କୁହନ୍ତୁ କାହା ନାଁରେ ଓକାଲତନାମା ଫାଇଲ ହେଇଛି କୁହନ୍ତୁ?
SR Raut, my lord. SR Raut, Smrutiranjan.
Smrutiranjan Rao. The Mr. Smrutiranjan Rao, learned counsel, submits that he has filed wakalatnama for the petitioner let the registry place the same on record. But when there is another counsel, if you have not obtained the consent, how did you file that? If it is a prisoner's petition, it is there. Asha, which he has filed on the basis of the prisoner's petition. If any prisoner's petition has been received, the registry shall also place the same on record. All right. The name of Mr. Devashish Sarangi shall not be reflected in the cause list henceforth. Yes.
List on.
It will come next week.
Okay.
Item 11.
May I please Lordship?
Yes, Mr. Das.
Present petitioner has been charged on section 302 and 34 of Indian
Agu
Penal.
reject itla na fresh.
It was initially it was rejected. Thereafter, my lord was
Just a minute. Reject ila mane jo 3594.
35 it was rejected.
3594 2020 reject heichi 812 2020.
Yes, thereafter, my lord was pleased to release one interim bail at BLPL number 5888 of 2021.
ସରୋଜ ମହାରଣା ତ
Yes, my lord.
ଏଇଟା ଆପଣଙ୍କର ଏଇଟା ଚତୁର୍ଥ ବେଲ୍ ଆପ୍ଲିକେସନ 2020 ରେ ଗୋଟେ ଫାଇଲ କରିଥିଲେ ଦେନ୍ 21 ରେ ଗୋଟେ ଫାଇଲ କଲେ 22 ରେ ଗୋଟେ ଫାଇଲ କଲେ ଆଉ 23 ରେ ଏଇଟା
Yeah, yes.
ସୋ 22 ରେ ବେଲ୍ ଆପ୍ଲିକେସନ ଆପଣଙ୍କୁ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଯାଇଥିଲେ ଦେଖି
For 3 months, my lord.
नो ସେତେବେଳେ 31/3/22 ବେଳୁ କିଛି ସାକ୍ଷୀ ହେଇ ନଥିଲେ ତ ବର୍ତ୍ତମାନ ପୋଜିସନ କଣ?
ବର୍ତ୍ତମାନ in the meantime, my lord, there are charge sheet shows there are altogether 24 witnesses have been cited, my lord.
Yes.
Till the bail application was rejected by the my trial court, trial court has also indicated 3 witnesses have been examined.
No, no, ଆପଣ ତ ବେଲ୍ ଆପ୍ଲିକେସନ ଫାଇଲ କଲେ କେବେ ଫାଇଲ କଲେ 27/7/2023
Yes, yes, my lord.
ସୋ 3.5 ମାସ ଗଲାଣି ୟା ଭିତରେ ଆଉ ସାକ୍ଷୀ ହେଇଛନ୍ତି ନା ନାହିଁ ନା
My lord, no instruction is there.
ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇ ନାହାନ୍ତି ତ ଯୋଉ କେତେଟା ସାକ୍ଷୀ ହେଇଛନ୍ତି ବୋଲି ଆପଣ ଲେଖା ହେଇଛି ତା ଦେହରେ
Impugned order shows, my lord, that was bail was disposed of by Lorna trial court on 31st through 2023. Three witnesses have been examined.
ଆପଣ ସିଡି ପାଇଛନ୍ତି?
Yes, I have the sheet.
And have you given those 3 witnesses at least to the state council?
Call for the status report.
Status report ମଗେଇ ଦିଅନ୍ତୁ ତାହେଲେ the learned counsel for the petitioner submitted that the petitioner is in judicial custody since
23rd 1 2020 23/1/2020
लिखले and he was granted interim bail by this court for 3 months in BLAPL number 7637 of 2022 ठीक तो
Yes. Yes, ma'am.
7637 of 22
Yes, I've supplied that copy to my lord.
नहीं नहीं इटा को अच्छा अच्छा नहीं इटा नहीं ओ सॉरी हाँ नहीं सेटा होची 5888 of 2021 as per order dated 31/3/22 ହେଲା and after availing the same he surrendered at right time and the rejection order which is dated 31/3/2023 indicates that out of 24 charge sheet witnesses code lega hai ji
I have examined the charge sheet. Charge sheet shows that 24 witnesses.
नहीं नहीं जो 3टा witness ହେଇଛନ୍ତି
Trial court has
three witnesses have been examined. Since in the meantime more than 3.5 months have passed, let a status report be called for from the London trial court. बाकी usual order कर देवे और एटा जो 5888 taken on record कर देवे जो है ना एटा धरम next week नहीं आसो. Yes. देखी दियंतु रेकर्ड फाइल एंड चिन्ह आसिलानी हाँ कुहतु
My lord, may take item 12, my lord.
wait
Yes, ma'am.
mention sorry jo
Yes, ma'am.
160
I had given copies of the orders passed by your lordship. Photo dicho, Ladi, photo dicho. এটা দিলে হবে কপি
দিয়ে
চশমা দাও তো।
से जो दीटा लोक PW4 वर्सन अनुजाई Mr. Das, you come to the bail order in 4605 of 2023 ଦେଇଛନ୍ତି ସେଟା
4605
05 अच्छा ଆପଣ this is a case of double murder okay so the material is the dying declaration of deceased Bhagwan Swain while being shifted to SCB Medical College Hospital in an ambulance. Okay, so
PW4 and 8.
PW4 and 8 are the two witnesses and they have named the assailants. So far as PW4 is concerned, general allegation against everyone. That means the person who, but he has specifically stated that one Balabhadra alias Papu Pradhan and Badiya Pradhan for the right legs of both the deceased. So that is the reason and FIR was not lodged in the name of this that person. So he was granted bail. So whether this petitioner also stands on the similar footing or not.
Petitioner was not named in the FIR.
This okay. This Pandava Pradhan's name. First এইটাও চেক করন্তু মিস্টার পাণ্ডব প্রধান নাটা এফআইআর ଅଛି না নাই এফআইআর আনেক্স କରିଛନ୍ତି
Yes.
No.
FIR.
I'm placing the FIR.
हाँ एफआईआर जो सेकंड पेज को पढ़ी जाऊँ तो जो तेरे नेम ऑफ द एक्यूज्ड पर्संस गुड़ा लिखा है
आज्ञा
ତା ଦେହରେ
Papu
ସେ
Pradhan, Jharia Pradhan,
ପାଣ୍ଡବ ପ୍ରଧାନ ନା ଅଛି ନା ନାହିଁ ଦେଖ।
Balabhadra Pradhan and 4 others.
ହଁ, so ପାଣ୍ଡବ ପ୍ରଧାନ ନା ନାହିଁ। Now you come to the evidence of PW4.
PW4 evidence.
PW4 ଆଉ PW8 ଦି ଜଣ ପାରେ ଡାଇଂ ଡିକ୍ଲାରେସନ ହେଇଛି ନା। Pass on the evidence. How you are not filing it? How can the bail application be considered? You are not filing any FIR. The statements, material statements, you are claiming parity. PW4 kahin? Okay. Let us come to PW4. Se mada part ta ko paragraph pe kohla? ये जो टाइम डिक्लेरेशन
ମଚୁର ଆରମ୍ଭ
ହଁ ଏମାନଙ୍କ ନାଁ ସବୁ କହିଦେଲା।
ନା କହିଗଲା
ତା ଦେହରେ ନାଁଟି ଅଛି କି ପାଣ୍ଡବ ପ୍ରଧାନ ନା ଅଛି, 104 ରେ ଅଛି, ପାଣ୍ଡବ ପ୍ରଧାନ ନା ଅଛି। But again he says that you come to the next page.
Having sword and lathi and assaulted them, but Manas Ranjan Singh managed to escape from their clutches. Thereafter, the accused person, namely Papu Pradhan and Balabhadra
alias
Pradhan, got the right leg of both the injured person and severe and took the same. I also recorded the above version of the injured Bhagwan Swine in my Vivo mobile phone through audio visual mode. This is a Vivo mobile.
ତେଣୁ ଏଇ ଦିଟା ଲୋକ ୟା ନା ହଉଛି ପାଣ୍ଡବ ପ୍ରଧାନ, ଇଏ ପପୁ ପ୍ରଧାନ ଅନ୍ୟ ଗୋଟେ ଲୋକ। କାରଣ ସେଠି ବି କହିଛି ସେ ଯୋଉ ତା ପୂର୍ବ ପେଜ ରେ ପାଣ୍ଡବ ପ୍ରଧାନ ପରେ ପପୁ ପ୍ରଧାନ ନାଁ ଅଛି। ତେଣୁ ପାଣ୍ଡବ ପ୍ରଧାନ ପପୁ ପ୍ରଧାନ ଅଲଗା ଅଲଗା ଲୋକ। ବାକି ଅନ୍ୟ କେତେ ଜଣ ଯୋଉମାନଙ୍କ ନାଁରେ ଜେନେରାଲ ଆଲିଗେସନ କରୁଛି ସେମାନେ ବେଲ ରେ ଗଲେଣି। ବାକି ଆସିଲା 8 ନମ୍ବର ସାକ୍ଷୀ। 8 କୁ ପଳେଇ ଆସନ୍ତୁ। He is another witness to the dying declaration. ये generally कौची have you got that statement?
No matter.
केमती अपन बेल मूव करेंगे ठीक PW8 टा देखो नहीं PW8 को कुछ साल वगैरह ना साल का था देखना चलो मुझे नहीं से जुड़े मेरा। So this Pandav Pradhan is in judicial custody since when? तो तारीख को ऊपर लिखा है 9821 वो पिटिशन ऊपर लिखा है जी अरे बाहर पिटिशन ऊपर लिखी थी वो पिटिशन तो दिया 9821 are the learning counsel for the petitioner, learn counsel for the state. Learn counsel for the petitioner submitted that the petitioner is in judicial custody since 9/8/2021. He has been charge sheeted under section so and so. Or देखी मोटी मारदूच देखी लिख देवे. Learn counsel further submitted the name of the petitioner doesn't find place in the FIR as an assailant of the deceased, namely Aditya Kumar Ron Singh and Bhagwan Swain. However, the name of the petitioner came in the dying declaration stated to have been made by the deceased Bhagwan Swai, while he was being shifted to the hospital before PW4 and PW8, and submitted that in the dying declaration, specific overt act has been attributed against two co-accused persons, namely Papu Pradhan and Balabhadra alias Baliya Pradhan, and similarly situated co-accused persons have already been released on bail by this court in different bail application, and since the petitioner stand in the similar footing, the bail application may be favorably considered. The learned counsel for the petitioner files the bail order copies of the co-accused persons with a memo which are taken on record. Learned counsel for the state, after going through the evidence of PW4 and PW8, fairly submitted that the petitioner is similarly situated like the co-accused persons who have been enlarged on bail. Appearing for the informant.
No, madam.
Acha.
Connected matter of detach.
Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, release of similarly situated co-accused on bail, absence of the name of the petitioner in the FIR, and taking into account the period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail allowed. Yes, next item is 267. Your.
Yes, madam.
271.
267 ढाला जितेंद्र स्वाई तार कस्टडी केबे
22 2020 madam.
केते
22 2020
22/2020 आना एफआईआर नहीं
ना।
अच्छा एटा आइटम नंबर 267 सेम ऑर्डर हबो किंतु डेट ऑफ कस्टडी टा होची 20/2/2020 हला अलाउड यस 271 सुशांत प्रधान आपण कस्टडी डेट केबे 27/2/2020 आउ एफआईआर रे आपण ना अछि तला आपण सेम फुटिंग केमति हेले
प्रेजेंट
हां पप्पू प्रधान ना अछि पूरा आइटम नंबर माने प्रथम अक्यूज्ड आपण पीडब्ल्यू किंतु से जो दी जण लोक भीतर आपण ना नाही
पिता चंद्रमणि प्रधान.
All right, the learned counsel for the petitioner submitted. This is item number 271. That though the name of the custody since 27 to 2020, though the name of the petitioner finds place in the Pappu Pradhan, son of Chandramani Pradhan. आपणकर बापा ना कौन पिटिशनर तो सेम लोक तो ठीक है फाइंड प्लेस इन द एफआईआर बट in view of the evidence of PW4, since in the dying declaration specific overt act has been attributed against जो दी जनक लोक ना bail application may be favorably considered है ना तापर बाकी अन्य जिंस गुडा को लिखिबे लेकिन अलाउ कर देना
198
This is interim bail.
माइक को एडजस्ट करी कोंतु
Lordship, interim bail order, your lordship. Under the petitioner in 3 months interim bail, your lordship.
198 रे कोन हला
And the petitioner is in custody, your lordship. 13/10/2020, your lordship. Already status report received, your lordship. Other co-accused persons are released on bail, Your Lordship. The petitioner earlier released on 3 months interim bail, Your Lordship. In time, he will surrender, Your Lordship.
ଆପଣଙ୍କୁ 21ଟା ସାକ୍ଷୀରୁ 4ଟା ସାକ୍ଷୀ
ଆଜ୍ଞା।
ହେଲାଣି ତ ଆପଣ ବେଲରେ ଯାଇଥିଲେ କେବେ ଇଣ୍ଟ୍ରିମ୍ ବେଲ୍ 28/9/2022 ରେ ଗଲେ ଏବଂ 26/22
In time, Your Lordship.
3 ମାସ ଆଚ୍ଛା ଇନିସିଆଲି ଆପଣ କେବେ ଆରେଷ୍ଟ ହେଲେ
Arrest, Your Lordship.
ଫାଷ୍ଟ
13/10/2020, Your Lordship.
13/10
ଆଜ୍ଞା।
yes Mr.
Yes,
Tripathi heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody in connection with this case on 13/10/2020 and he was granted interim bail for a period of 3 months in who case number kete hai?
ଆଜ୍ଞା। Interim bail order ଟା।
In BLAPL number 3293 of 2022 as per order dated 15/7/2022. And after availing the same, he surrendered at right time. And since there is no such progress in the trial, the bail application may be favorably considered. Peru the status report of the London trial court dated 13/9/2023, which indicates that out of 21 charge sheet witnesses, 4 witnesses have been examined so far. And the petitioner, after availing the interim bail period, surrender at right time. And counsel for the state opposed the prayer for bail, like 3 months bail grant for them. Yes, disposed of.
May I please? My lord, the petitioner is in custody, my lord. Last occasion, lordship directed for instruction.
Who order? Order number?
Order number 18.
18/10/23
So and so. I said the interim bail on the ground of Kona Sila. ଆପଣ କିଡନୀ ପ୍ରୋବ୍ଲେମ ଆପଣ ଗାଇନୋକୋଲୋଜିଷ୍ଟ ପାଖକୁ କଣ ଯାଇଛନ୍ତି ତାଙ୍କଠୁ ଗୋଟେ ରିପୋର୍ଟ ନେଇ ପଳେଇ ଆଇଲେ କଣ କରିବେ ରିପୋର୍ଟରେ କଣ ଆପଣ ଇଣ୍ଟରିମ୍ ବେଲ୍ କେମିତି ଦିଆଯିବ ଆପଣ ଯୋଉ ରିପୋର୍ଟଟା ଆଣିଛନ୍ତି ସେ ରିପୋର୍ଟଟା ହଉଛି ଗୋଟେ ଗାଇନୋକୋଲୋଜିଷ୍ଟର ସେ ଲେଖିଦେଇଛି କିଡନୀ ପ୍ରୋବ୍ଲେମ ପାଇଁ ଆପଣଙ୍କର ଅପରେସନ ଦରକାର ହାଉ ହି ଇଜ କମ୍ପିଟେଣ୍ଟ ଟୁ ସେ ଗୋଟେ ଭଲ ରିପୋର୍ଟ ଆଣନ୍ତୁ ଆଉ ଗୋଟେ ଫାଇଲ କରନ୍ତୁ BLAPL number 7242 of 2023. The London Council for the State has produced the report of IIC, Lohunipada Police Station, Rourkela. As per order dated 18/10/2023, the London Council for the petitioner, in view of such report furnished, seeks permission to withdraw the bail application to file a better one. Disposed of as withdrawn. Yes.
May I please lordship. Sir, in this case, the victim girl came with her principal accused Badal Pale, and I am the person who arranged the.
Wait.
I am in custody from 21/5/2023.
210 PLAPL 7680 2023. এটা কেবেଠୁ କଷ୍ଟଡି ରହିଲା ଆମ କେସ୍ ଡାଇରୀ ଅଛି ତ?
Yes, sir. 21/5/2023.
21/5
2023.
hmm.
Charge sheet has also been filed.
So
My lord, here the allegation against that one initially there was on 363, my lord. Where, my lord, the allegation is that one Badal Pali has kidnapped the minor.
no, what are the offenses under which charge sheet submitted?
Charge sheet has been 363, 360,
Go slowly. 363.
366A.
Yes.
376-2N.
Yes.
376-3. 6 of poster and 114 of IPC and 17 of
6 and 17 of POCSO Act.
yes, ma'am. 114 of IPC.
Notice to be go, my lord.
Notice जाइनी.
Like the confirmation.
Yes.
Verification of documents, lordship. I have already filed the documents.
कौन verification हवा?
This RR गुड़ा verification de.
Oh, you are a man from
West
Murshidabad
Bengal.
district. Okay.
Murshidabad, lordship.
And you have also supplied the local sureties document.
Lordship.
ଆପଣ ଦିଟା ଆଗ କିଛି ପାଇନାହାନ୍ତି? ମାନେ address verification ଆଉ local surety.
ସେଟା ବି ଆମର ଯାଇଥିଲା ଯୋଉଟା ସେଟା ବି ଆସି ନାହିଁ. I waiting for this ସେମାନେ ବି follow କରୁଥିଲେ. ସେଇଟା next week ଦେଖିବୁ. Okay.
Learning council for the
earlier ଏମାନେ co-petition ନେଇଥିଲେ ବେଲେ ଦି ଜଣ lordship. Co-petition
report ପୁରା ପାଇନାହାନ୍ତି ଆସିଲେ ସିନା ଯାହା ବିଚାର ହବ. The Learning Council for the state submits that the matter may be taken off next week in order to comply the order dated 6/10/2023. Please this matter next week, next Friday. Yes. এটা କେତେ number ଗଲା? 256. Okay. Yes. ଆଉ ଗୋଟେ ଡାକ ଅଛି ସମୟ 5 ମିନିଟ ଡାକିଲେ ନାଇଁ ମେନସନ ହେଇନଥିଲା କିଛି ଯାହା ମେନସନ ହେଇଥିଲା ଡକ୍ଟର ଆଇସାରାଣୀ ସିରିଏଲ ଯାଅ
342
ମେନସନ ଅଛି ତାହେଲେ ଆଉ ଗୋଟେ ଡାକିଦିଅ କେତେ 321 not
20B2C 40 kg of ganja.
No, 321 तो कहीं मेंशन करना थे नवकिशोर गुरु हाँ
341 कहतील नहीं 21 भी कहतील
कौन 321 नहीं तो नहीं छाड़ दो तापरे
मैं प्लस में petitioner is the juvenile minor
339
yes madam his observation home since 8/4/2022 that's social investigation was called for
what are the offenses under which charge is submitted
302-201 of the IPC the FIR I have annexed that is lodged against unknown person
charge sheet को उतरला 302-201
of the IPC madam
what is the name of the deceased
Bignoraj Putel FIR was lodged on 31/3/2022 on 28/3/2022 deceased was found missing On 31/3/2022, his dead body was found nearby a canal, and accordingly, FIR was lodged against unknown person. During the investigation, the brother of the present petitioner, namely Kailash Patel, was arrested, and he confessed. Not only he confessed that the wife of the deceased had illicit relationship with him, which was once he saw that subsequently he had revenge to he had intention to kill the deceased, and the present petitioner accompanied him for commission of the crime.
No, you mean to say that except the confessional
No materials.
statement of co-accused before police, there is no other material?
Yes, madam.
Who is that co-accused?
Kailash Patel. That one statement is Radhesham said. He stated that in presence of I am reading the relevant portion. ଆଜି ଗତ ଆଜି ଏଇକି ଯେ ଆଜି 2/4/2022
No, ଠିକ ଅଛି ଆପଣ
Witness to the confession.
witness to confess.
ଆଉ କିଛି material ନାହିଁ?
Social investigation report.
କେତେଟା କେସ୍ ଅଛି?
ନାହିଁ କିଛି ନା
ନାହିଁ
କେସ୍ କିଛି ଇଏ ହଉଛି ତାର ଭାଇ।
There was delay. All the delay has been condoned in criminal division.
सब condone ହେଇଯାଇଛି already delay condone on 2/2/2023 mail. My order dated 2/2/2023.
Okay. Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submitted that the petitioner is a young boy, aged about 16 years, and he is detained in observation home since 8/4/2022 and has been charge sheeted under section 302(201) of the Indian Penal Code. The FIR has been lodged against unknown persons, and the only material available on record against the petitioner is the confessional statement of co-accused Kailash Patel before police. And there is no criminal antecedent against the petitioner, and therefore the bail application may be favorably considered. Learned counsel for the state has produced the case diary, and after verification of the same, while not disputing that the only material available against the petitioner is the confessional statement of co-accused before police, place the social investigation report, which also indicates that there is nothing adverse against the petitioner. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, period of detention in the observation home, and for the taking into account the age of the petitioner, I am inclined to release the petitioner on bail. Juvenile se jo format achi lekhi debe eta dei diyantu. Yes.
This is a juvenile
341 ଆପଣଙ୍କର ମୋବାଇଲ ବାଜିଲା ନିଆଯିବନି ଆଜି ନେକ୍ସଟ ୱିକ୍ ରେ। ଆଉ ଟାଇମ ନାହିଁ ଆସନ୍ତା ସପ୍ତାହରେ।
and I may pardon supplementary list. Juvenile division ଟା supplementary ଖାଲି।
342 is juvenile division. 342.
343, my lord.
344 my lord.
342 also juvenile. My lord.
I don't want to one. I don't.
ଜଣେ କହିଲେ ସିନା ହବ, 1000 ଜଣ କହିଲେ କଣ ହବ? କିଛି ହବନି।